Yes, sir. To mention a lot. So, DIXIT 2023 is a common matter. Similar matter has been decided by this Honorable Court in Codical Bench. Can it covered by that? Yes, 2000 tomorrow. 2000.
Not that urgency. Court does not work that.
That's too much.
2000 matrimonial appeal. 2023 appeal.
That is your appeal or state appeal?
My case.
Your appeal or state appeal?
State has filed.
So you please provide that copy to them.
Yes,
where you say
yes,
that is covered.
My similar matter. Directive filed with 2023 by government. It's not taking any steps. Now because of the pensions are not getting pension. And in the confirm that they only start detail pending.
And matrimonial appeal has been fixed to 10th, my lord.
Yes.
It has not come. One has been filed by the husband against the decree of dismissing the decree of divorce. Another by the wife against the dismissing the petition for restitution of conjugal rights. Both are flocked together, but they did not
yet come.
10th, it was fixed to 10th by the
other bench.
Yes, my lord.
Take this matter on the 5th of August.
5th of
August.
Obliged.
Order of cancellation of promotion and order of recovery.
Recovery is ordered.
Already ordered, madam. 2023 matter. So, next week or?
Next week we have difficulty. This month we have difficulty.
First week of August, you will
6 or 7. Not.
Okay.
The fresh admissions reduction.
Is it covered by Rafiq Masi?
Yes.
Fresh admission reduction to 2024 minutes. The case relating to release of a salary for 2 years.
2 years. All right. The second week of August.
Fresh admission matrimonial appeal.
Matrimonial appeal. Which
Fresh matter.
With fresh matter.
Fresh matter.
On 6th of August.
I want to make a mention, my lord. Item number 14.
1 second. Wait. Call page 1.
Page 1, 1 to 3, page 2, 4,
I said page 1. Page 1 means page wise.
Yes. Page 2, 4 to 9, page 3, 10 to 15, page 4, 16 to 23, page 5, 24 to 29, page 6, 30 to 33.
33, my lord.
33.
After recess, my lord, be taken up.
After recess.
After recess.
After 2.
Yes.
Call it.
After 2.
No, if somebody mentions, just mark it. Just mark that.
33.
All. Inform your friend also.
Also,
It's a 2014 matter. State is the
Item page 7, 34 to 37, page 8, 38 to 42, page 9, 43 to 46.
My lord, item 44 can it be taken up 2 p.m. my lord?
44.
44, my lord.
Huh.
Urgency is there, my lord.
We are agreeing. Still you want to argue.
Okay, my lord. Obliged.
So no priority. If it reaches, it will be taken up.
There is some urgency. That's why I'm.
So you have to mention the urgency when the matter reaches. Because everyone is mentioning the matter to be urgent.
Kindly taken
And
up
it's a 24 matter.
You come back to
My lord, item 46, my lord.
46.
For adjournment, my lord, the talk of compromise is going up between the parties. And for the restaurant.
46. Talks are going up.
Yes, ma'am.
It is submitted at the bar that the compromise talks are on. And therefore some time be granted. First, we agree. Post this matter in the 3rd week of August 2025. Okay.
Item 1 for judgment.
Yes, we have structured our judgment on the basis of discussion made by the apex court in that SLP matter, number 1. And one of the important factors we have adverted to is the provisions of sub-rule 3 and sub-rule 6 of Rule 18. Very importantly, These rules are not put in challenge, and therefore we have invoked Ramakrishna Dalmia versus Justice Tendulkar of Justice B.K. Mukherjee's judgment, saying when rules are not challenged, they enjoy presumptive validity. Then we have rejected the invocation of doctrine of reading down. Even reading down cannot be done. Sirwai says reading down cannot be done unless challenge is linked to the rules. Therefore, that also we have rejected. So literally, we have gone by the text of sub-rule 6, which is in contradistinction to sub-rule 3. Sub-rule 3 speaks of work-charged employees. Sub-rule 6 speaks of job contract employees. And their text is also very, very different. The language of these sub-rules is different. Therefore, broadly, we have agreed with the views of the submissions of learned AG, and we have allowed the appeals with the one caveat. There are cases where you have not regularized the services in time. You have regularized services after 30 years. Some cases came before us. So where court directs the regulation should be from anterior date, then that date onwards, entire service will be countable. That observation we have made, but that we have not treated in depth because the pleadings were lacking. The language of the pleadings was not good. Legal content of the pleadings was lacking. Therefore, within our wisdom, whatever we could grasp, we grasped and we have structured our judgment. How many of you will be happy and how many will not be, we do not know. It's not our concern also. In the above circumstances, these appeals having common law and facts are allowed. The impugned orders of the learned single judges are set at naught. The writ petitions filed by the respondent employees are dismissed. Courts may ease. Nakara, Devaki Nandan, these also we have referred. Some advocate had argued that one. That also we have treated. I agree. Small changes are required. Some grammatical mistakes and other things have happened. So we'll rectify and then we'll give it to your side.
And provide the list of all the SLPs which have been remanded.
You get the question.
But week after week, you are not doing that.
Because one of the rate of many.
So 80% whatever you have done, you please provide it along with the list to the registry.
So that matters can be.
So that it becomes a logical end. You see, after all this effort also, we do not know where the court has directed for regularization on a particular date. So, I mean, the difficulty was to understand also. So, all those matters have to be listed. No, but it's simply now remanded by the Supreme Court, writ petition and SLP number. Those things. You don't have to download the prints, I think, because the registry will do that. You simply provide the number.
Writ
application, there are 6 to 8, 10.
Correct.
Give them.
Give them.
Give them. See, pendency has to go down. Otherwise, people think that Orissa High Court is not working at all. That impression we can't give. Pendency should go down.
200 cases.
Is it not? So that the cupboards become free, where new cases can come. We can address the new cases. That way. Okay.
I come to
200 and that 450. The
Yes. 2001 SC. Thank you. Thank you so much. But much law has developed after K.T. Thomas's judgment. To some extent, it is loosened because Fitzgerald coined Section 112 of the Evidence Act when DNA test was not known. Because of the advent of science, now there is some discussion. A lot of law is developed on this after that N.D. Tiwari's case. Okay, just look into that also. Yes.
Item 5.
May I please, Your Lordship?
Yes.
Your Lordship, the appellant institute is challenging the judgment dated 19/4/2024 under Annexure 12, wherein the learned single judge has directed the institute to give appointment to the respondent number 1, was not recommended by the selection committee for the advertised post, and by misconstructing the evaluation sheet of the selection committee as a panel, the direction was issued to the institute to give appointment to the respondent 1 on the basis of his position in the panel, which is not at all a panel, Your Lordship.
So that
Your Lordship,
learned judge has treated that.
Your Lordship, may place page 82 of Annexure 12. Page 82 of my brief, Your Lordship.
82.
Page 82, Your Lordship, at para 6.5. May I read, Your Lordship?
Where is your contention with regard to this in your objection statement before the learned single judge?
Your Lordship. Your Lordship, may I kindly see Annexure 11 is my counter affidavit.
Annexure 11.
Your Lordship.
Go to
Annexure page 46.
At page 46, my counter starts at page 46.
Which paragraph?
Your Lordship, may kindly see page 52. Page 52, Your Lordship, the 2 lines from the bottom of page 52, I'm placing that portion, Your Lordship. At the cost of repetition, it is once again submitted that the petition filed by the petitioner challenging the letter dated 27/10/2023 to appear before the selection committee for personal interview by relying on the fact that the interview process was completed on 26/3/2015 is grossly unjustified, inasmuch as on the evaluation sheet dated 26/3/2015 prepared by the selection committee, the petitioner was not recommended for the post of technical assistant, video editing, and no panel of eligible candidates were enlisted by the selection committee as per clause 14 of the advertisement number ES bar 03 bar 2014, which precludes the petitioner from seeking appointment after termination of Abhinash Biswal without appearing before the selection committee again for personal interview.
Let us go to that rule position, which
Your
are the
Lordship.
regulations, rules.
Your
You mean
Lordship,
to say that he never faced the selection committee at all?
he had faced the selection committee, but the selection committee had not recommended him for the post.
Where is that panel of selection?
Your Lordship. Your Lordship, may kindly see Annexure 4
Select list is there.
at page 28, Your Lordship. Your Lordship, 3 candidates were
2, 3 were there.
3 candidates were selected for the personal interview, Your Lordship.
Respondent was not there.
Respondent was there, Your Lordship.
One of the 3.
Your Lordship.
Who is he?
He is Abhijit Patnaik, Your Lordship.
Abhijit Patnaik.
Your Lordship.
Number 2.
These
Number
3
2.
candidates, Your Lordship. Number 2, Your Lordship.
What is this list?
This is evaluation sheet of the selection committee, Your Lordship.
Kindly see the heading. Final evaluation sheet.
Your Lordship.
You mean to say evaluation sheet is one thing, select list is another.
Your Lordship. As per the selection process, there are 3 stages of selection, Your Lordship. First 2 stages are scrutinization. Third stage is the personal interview. The candidate who passes all the 3 stages and on the basis of marks he has obtained in all the
Then
3
select
stages,
list will be prepared.
select list will be.
Where is that rule position?
Your Lordship. Your Lordship, may kindly see Annexure 2, Your Lordship, at page 26.
Annexure 2.
Your Lordship, at page 26.
No, this does not say rule position.
Your
It
Lordship,
only shows the exercise done under the rule.
Your Lordship, there is a noting there just below the table. Final merit list
Will be
based on marks in stage 1 and stage 2. Test 50% plus career evaluation 20% plus personal interview 30%, Your Lordship. So, Your Lordship, as per the
There's the
advertisement,
last slide. Please place the last slide.
candidates will qualify stage 1 and plus stage 2 test together will only be considered for personal interview, Your Lordship.
Interview is subsequent. Interview is subsequent.
Your Lordship.
That interview he did not do.
He faced the interview, Your Lordship, but he was not recommended. And only one candidate.
He was not selected.
He was not selected, Your Lordship. Only one candidate was selected and there was no panel prepared, Your Lordship. Not recommended. Yes.
And Avinash Vishwal, did he join?
He had joined, Your Lordship.
Resigned or?
He Abhinash Vishwal, after he joined, the present respondent one filed a writ petition alleging that he had produced some fraudulent documents at the time of selection. So his appointment may be forfeited, Your Lordship. Your Lordship, an inquiry was conducted by the institute. Your Lordship, it was set aside after a due inquiry conducted by the institute. Your Lordship, the institute gave an report before this honorable court that since he has submitted fraudulent documents, we have conducted an inquiry and set aside the appointment. Then, Your Lordship, this honorable court disposed of the writ petition filed by the respondent number 1 with an observation at page 35, Your Lordship. May I kindly see? This is the first writ petition. At page 35, annexure 4. Your Lordship. The observation of this honorable court was that there is no panel as such. So he is not getting any right to get appointed after termination of the
challenge. But say, even if he challenged the selection process and succeeded, he cannot get the benefit of such judgment.
Your Lordship.
By terming that list to be
a panel, Your Lordship. Your Lordship.
But is? He has secured the second mark. You are disqualified or not entitled or there is any qualifying mark.
Your Lordship, as per the...
If he would have challenged, Vishwan would have been terminated or resigned, then those kind of cases that were subsequent resignation of a candidate without able to the benefit of the next but your case that if this particular challenge
Your Lordship,
was out of the reports. Then vacancy arises. You have to you can't say that he did not face the interview. He faced the one, but he was objected below. Therefore, not recommended. Kindly listen to us.
Your Lordship.
Listen to us. You was daring to the judge's question. Then you can ask that. He faced the interview. Then you can't say that he did not. Otherwise, you would not have been. This not recommended certification role because there were 3 persons in the play. You had enlisted, shortlisted, 3. One of them is responded. Correct? And the person who was recommended, that appointment was satisfied. That's right.
Your Lordship.
If that is so, then is going to redo the certification because it is always comparative assessment 3% of them who are the best. Now one is cut off, he goes out of the thing because of the order in the repetition which are he was the repetition.
Your Lordship.
Then obviously his percentage would be comparatively higher
Than the person who has been struck down.
So 37. Page 37. It's a click scroll down.
That paragraph.
The following is therefore. Let's make it principle.
Kindly mark 37 para 9. Case of
Your
the
Lord.
petitioner is.
The respondent number 1, Your Lordship.
So you have challenged that order. Para 9 you have challenged.
Your Lordship, we had not challenged that order. Your Lordship, may I place only the facts. The advertisement was for.
What is the order? Let us see what is the order.
Your Lordship, for the foregoing reasons, therefore the writ application is disposed of, directing the opposite part number 2 and 3 to consider the case of
yourself.
Your Lordship.
Correct.
Case of the petitioner for selection against the vacancy created by termination of service of opposite part number 8. A decision in this regard shall be taken within a period of 4 weeks from the date of communication of this order or on production of certified copy thereof by the petitioner.
Did you undertake that exercise?
Your Lordship, we had given, after this order was pronounced, we had issued a communication to the petitioner that since the advertisement was over due to the termination of Abhinash Bishwal, so we are giving a special liberty to you to appear for the subsequent advertisement and select any post.
So that amounts to violating the
Violating and rewriting.
Your Lordship,
See, you could not have.
Your Lordship, thereafter,
It is not your case that you challenge the selection process as the selector.
Your Lordship, thereafter,
Please listen to us.
The problem is that
Listen to us. We come after burning the midnight oil, and we have burnt midnight oil for years. With very humility, we are saying this.
And-
Otherwise, extempore would not have said all these things.
and court proceedings are never monologues. The difficulty would be that you are arguing so well. You just forget this habit of going one-dimensional and presenting your view only. Be receptive.
Page 37.
It's very clear. You do not challenge, but you have taken that to be liberty to you.
Virtually, you said I
redo the whole thing.
No, not only that.
And
He says, this is not applicable to me. Court order, if the court tells, jump from the 5th floor, unless you bring the stay, you have to jump. No, if I jump, I may, something may happen to my organs or to my life. It's no defense. It is a mandate of the court. Is it not? Therefore, there is a direction. This direction is pursuant to the earlier selection process. You are asking him to stake his claim in next recruitment process. That cannot be. That cannot be. Even first year law student, if he reads this operative portion of the order, can understand what is that. It may be a wrong order. A wrong order is nevertheless a binding order. A wrong decree is nevertheless a binding decree. It may be wrong, arguably, but that does, because in that question, it is you are restudicated from that submission. Restudicator applies even to the writ proceedings, whether section 11 of CPC is applicable or not. Restudicator, doctrine of restudicator operates divorce section 11 also. Therefore, we don't think that what learned single judge has done now, that is consistent. It's a further step. It's a concomitant of the earlier product of the litigation. Though very elegantly, very clearly you argued. What's your answer to this?
And if you, did you write such a letter that mentioning that since the process is over, you have to do it again?
Your Lordship,
That is per se in direct conflict with para 9.
Direction. It could have been a ground in your writ petition. Sir, we cannot do it. Let him appear in the next recruitment process. Perhaps court would have agreed also. We do not know what court would have. We cannot be speculative also. Now there is an order. An order is an order is an order. You have to abide by that order.
Perhaps you could not have taken that stand also. Then you would have been apparently selective, tilting towards Patnaik or Vishwan. Was it your stand that since the entire selection process is over, this selection process is no more valid, but rather because the selection was valid, you went on investigating the successful candidate, and you arrived at a conclusion that he has furnished documents which are either false or incorrectly obtained. So,
Your Lordship, may I only place para 8 of the judgment?
Right,
which your
of the
Lordship-
judgment. Of the
We are
earlier
referring to
judgment or this
page 35, Your Lordship. The
Page
first
35.
petition.
Scroll to 35. What does it say?
Your Lordship, at page 35, para 8.
You
In
just
the-
say what it says, then read.
Your-
That's advocacy. Is it? Advocacy means what is there, you should make a statement on that. Then to vouch it, you should read it. That's advocacy. Otherwise, reading. Reading is not advocacy. Now tell what the paragraph says.
Your Lordship, the paragraph says that Abhinash Biswal was appointed on 1/4/2025. The candidate was terminated after inquiry of the institute. Then the paragraph further says that there was no panel created by the selection committee. So merely because the respondent number 1 was called for an interview.
You are not reading para 5 properly. It is your submission.
Para 8, Your Lordship, at page 35.
Paragraph
Referring to
para
para
8.
Your Lordship.
Go to 34. Internal page. The internal page is
Internal page of
judgment.
Your Lordship is page 5, Your Lordship.
Page 5. Para 2.6.
Your Lordship, I am referring to annexure 4, Your Lordship, at page 35.
Para 8 has a consequence of you avoiding to answer that by selecting a person who had wrong credentials, by selecting the consequence, in fact, you did not answer in that particular petition. If you would have found in the proper time while selecting the candidate who had wrong credential or false credential, then who would have been the candidate selected by you? That you avoided to answer.
Obviously, this candidate.
This candidate. I mean, it's not that difficult also. If your stand is that he's otherwise ineligible, it is open and shut. But you did not, instead of answering that, you have meandered into a series of arguments that it was for 1 year, it was not for. You see, somebody getting selected by a process which conducted by you, but you are rather defrauded. That is your finding. So what would be the result if you would have found out, done the right thing at the right time?
You would have been selected.
You took 9 years after court's intervention to find out that you selected a candidate with wrong or improper credentials. Is it not? Or you say you have a different...
Your Lordship, during the pendency of the writ petition?
Not during the pendency. You had selected the candidate proper, then how could you terminate his selection? Because this is your case that you selected him based on certain documents which were fraudulently obtained or wrong, or they are simply manufactured documents. So can you do that?
Your Lordship,
Can you select a candidate with wrong credentials?
We are asking only one question. Had you not selected him, he would have been in. But for his selection, he would not have lost the case. Therefore, but for test is applicable. If that is so, the order of the learned single judge is sensible. Maybe little, every order we can find some wrong thing. That is not a ground for you. You have to show order is wrong and it is unsustainable also. Not just mere wrong. There will be grammatical mistakes, names will be mistaken, many mistakes will be there. But that is no ground for appeal. You have to show order as a whole is unsustainable. That's not there. Let us see
Your
whether
Lordship,
your friend can improve your case.
clarify.
Yes, Mr. Rath.
My lords,
You appear for whom?
he's doing on my behalf.
On your behalf. You want to say anything?
Lord, what happened in this case? I am just placing the fact.
Please don't repeat because
No, I am not.
Add something.
he being the junior, he has done so well.
That
Yeah,
when
good,
he
very
filed the writ petition before this court, and we conducted the inquiry. That is not a factor. He filed challenging his selection. And it came to the notice of the authority that he has
produced some forged document at the time of selection. On that basis, an independent inquiry was conducted, and it was found.
You're only repeating what he said about thrice.
Not on the basis of the direction of this honorable court.
Then assuming that on you, then you are still worse off.
Then much worse off.
You are worse off.
Then much worse off. Because you see, you have the only excuse now.
What I'm trying to impress here.
And you don't. I mean, it's not that. I'll stop addressing also you if you want. But it's not that way. You have the only plea to save you that because it was due to court direction. If you argue that, if you go to that extent of arguing that it was not court direction, but we are on our own found out, then it is still worse.
The case of the others.
Still worse. But fact remains, at the time of selection, one person was selected. And somehow, some reason or other, he found that he is not eligible, or he has produced some documents which is not in consonance with the advertisement, what is the requirement under the advertisement. So therefore, after his appointment was cancelled, there is some judgments of the Honorable Supreme Court. So whatever may be the reason, if one appointment has been cancelled, and there is a panel, it is not called a panel, but it is a recommendation by the selection committee. And one person has been recommended and the other persons are not recommended by the selection committee, then the selection will be confined to those two persons after the selection was set aside. And because of their name was not recommended. Once it is not recommended, the authority has to conduct a fresh selection.
Mr. Sahoo, can I ask you a question?
Yes. That is the some judgments are there.
So there is not a single judgment. With confidence, I can tell you, whatever little I have read. How many candidates you could have recommended at the first instance?
One. The selection committee will recommend one.
So that answers the issue. After selection process, at the most and at the minimum, you can recommend one. You can terminate other candidates to be not recommended, but that doesn't take away the selection process that has undertaken.
No.
They have gone through the process. There is not a single decision like
absolutely
this
right. Absolutely right, Mullah.
So,
and it will be confined between those persons who were not recommended. That is and we said that before the Honorable Court by filing affidavit that we will confine the selection only to those two persons. Because the selection committee has not recommended their
Mr. Sahoo, you are actually what you are doing. You are again reinventing the wheel. After carrying out a valid selection process, without any reason, you want to make another selection process without any justification, without any requirement also.
Let's take note of some judgments.
What you mean to say is, merely because that selection is faltered,
yes,
this will not result into automatic selection. So facto will not be a selection.
That is
again, selection process has to take place.
Has to take place
from amongst the two.
From amongst the two. Those two.
But what about, so your selection process earlier has been held invalid by the court?
No, selection process
where you say you rely on that page 4, annexure 4. Has it been declared to be invalid by any process?
No.
Or after the judgment, was it your stand also? That the selection process of selecting 3 persons, recommending one, giving 64% to Biswar, 51% to Abhijit Patnaik, and some 50% to other one. Why have you ever said that it's an invalid process? The entire selection process goes. You see, there is no challenge to the selection process. It is not your stand that since the selection process was invalid, so everyone goes. Rather, now as you have, stated that it is challenged. And you see that
You comply with the order of the single judge case 37.
Yes, madam. Your Lordship, Your Lordship, kindly bear with me. Your Lordship, kindly read that judgment a little before me. Yes. Yes, ma'am.
We are just asking. There is a mandate contained in the para 9.
Yes, ma'am.
There is a mandate.
Yes, ma'am.
Then did you comply with the mandate?
Yes, ma'am. We have issued notice. Your Lordship, kindly see. We have issued notice to those two persons.
See,
Yes, saying that selection, that notice was challenged before this honorable court without appearing before the other. We have confined between these two. Yes. May I supplement your Lordship by a judgment of the Honorable Supreme Court?
Which paragraph?
2002, Volume 1, SCC.
Name of the case.
The name of the Honorable Judges is?
No, case. What we should do with the judge?
It is State of Punjab versus Raghvir Chand Sharma and another.
But the fact matrix of that case are different. We referred to that judgment about 1 month ago, along with when I was sitting with Honorable Justice Mahapatra ji. The fact matrix of this case, so proposition which you say,
proposition is the ratio is page
2002
1 SCC, page 113, and paragraph 4. Paragraph 4. Wait a minute.
No, these facts, so the even proposition is not applicable. Proposition is not applicable. Now, we'll put, there are many principles competing with each other. We have to choose one of them now. One is where only one candidate could have been recommended, and the recommended candidate failed because of some judicial proceeding, some inquiry, X, Y, Z. Then the person next below has to be appointed. There is some force in this also. There are some judgments which you said. There are some judgments. Very contrary also.
May I permitted to read one sentence
Yes.
from that judgment?
Yes.
That paragraph 4, the sentence starts to is rightly contended.
Paragraph 4.
That is rightly contended. We have carefully considered.
Fourth line, paragraph 4.
The fourth line paragraph.
Fourth line.
You are right.
As rightly contended for the appellant state, the notification issued inviting applications was in respect of one post, and the first candidate came to be appointed, and it was only subsequently that he came to be resigned. Whatever may be the resign.
So that to younger Mr. Sahoo, I had asked this question, that if he had resigned, then he has no case. He joined, suppose, he joined, then resigns. There is a consequential vacancy even within 1 year.
So kindly allow me to
No,
that's
that's
next sentence. with the appointment of the first candidate for the
No,
only.
you didn't say that when I'm reading to, don't interrupt me. So that is how I didn't intend to interrupt.
No, that I am.
As a judge, I
I
am
am
just
not with
asking
that
you.
impression. मेरा तो problem. For your lordship's appraisal, with the appointment of the first candidate for only post in respect of which the consideration came to be made and select panel prepared, the panel ceased to exist and has outlived its utility.
Correct.
At
Because
any-
appointment
at-
was done.
At any rate, no one else in the panel can legitimately
Claim the
claim
post,
that
vacancy arose
he
to that.
should have been offered appointment.
Correct.
Either in the vacancy arising on account of subsequent resignation of the persons appointed from the panel or any other vacancies arising subsequently.
Correct. Because the select list is operative. The select list is operative, appointment has been done.
Yes.
Suppose next day he dies, vacancy arises. The persons next in order cannot say, no, we should be appointed to that one. Because it is a complete operation of the select list itself. But where the select list contains a defect pursuant to which the candidate came to be dropped, then this proposition is not applicable.
Then your lordship.
So just Raghvir Chand. Raghvir Chand, since that's your trump card.
No, Raghvir Chand and the other decisions.
So Raghvir Chand, since you opened your arguments with Raghvir Chand, Raghvir Chand, in which way is identical to this case? In your what I'm
submitting before your lordship, whatever may be the reason of the vacancy of the post.
No, let us not make it abstract to that extent.
That is a
Whatever
very
it
broad
is.
proposition.
No. A person who was appointed, he resigned.
No, Raghvir Chand, you see, there is even rule. There is even rule that the select list is for 1 year.
Yes.
The selection rule or the recruitment rules provide that. The argument would be, since the recruitment rule provides for 1 year, then for 1 year, everyone is waiting to be appointed. Supreme Court has said no. Once the appointment process is complete,
Over.
only exception to that is that somebody not turning up for getting appointed.
Appointment itself. Very initial
The
appointment.
initial appointment, then even to that strict is the interpretation. So that citation I can give you. Even that is way ahead of Raghvir, that even when the rules prescribe this for 1 year,
We have
still he cannot claim because somebody has joined. He cannot claim.
suppose the candidate himself, selected candidate, does not turn to the post at all. Then we go to the waiting list. But this is not such a case.
This is not such a case.
But anyway, we have understood your proposition. What you say is, I will articulate your proposition. Regardless of cause of accrual of vacancy, the candidates in the list cannot lay a claim for that. They should undergo fresh selection, if at all recruitment process is initiated afresh. This is your broader proposition. Because which you read that paragraph, that gives that impression.
And
That was the case where the candidate reported for duty. That was the case. The post was not kept urgent. The marriage took place. The candidate reported for duty. Then the vacancy arose. The other candidate said, vacancy has arisen, therefore operate the list and give us the position. Court said no. It's sensible. But this is a case where a person has been, appointment has been set at naught because of fraud. Because fraud vitiates everything. If fraud vitiates, it vitiates from the first day. Lord Edward Coke said centuries ago. Fraud vitiates everything and it vitiates ab inceptio, from the beginning itself, which you have seen in Changalavarai and Naidu,
Yes, there are a lot of
these
judgments.
cases, not many judgments. Therefore, that appears to be the. Then let us see whether they strengthen even.
What I'm saying.
then one more aspect, Mr. Sahu. Can I interrupt you with your permission?
Yes. No.
Raghvir Singh does not deal with a case where the appointment is interdicted by a writ petition. And in your case, writ petition along with an independent inquiry by you. And factually, the writ petition is filed earlier.
Writ petition was filed earlier.
So,
Just after
Ranveer Singh or for that
selection,
matter,
this writ petition
Ranveer
was.
Singh so when the selection date was, younger Mr. Selection date was?
Your Lordship, the Abhinash Vishwal was appointed on 6/4/2000.
Selection process is date is
26/3/2015, Your Lordship.
No, 26/3/2015. That's annexure 4. When the writ is filed,
It was filed in 2016, Your Lordship.
2016.
Your
Inquiry when initiated.
Lordship, inquiry was in 2022, Your Lordship.
So just mark it. So Ranveer Singh is not a proposition on that point. And you have better cases than Ranveer Singh on this point, that select list validity, and when the rule even prescribes for 1 year, still the selected candidate doesn't have a right.
Like here is also rule is for 1 year. Validity is 1 year.
And
The selection, the rules
and the writ petition is within much before 1 year of
1 year.
appointment of
Appointment of that
Vishwa.
Avinash Vishwa. But may I suggest one thing?
No, the second citation you wanted to say.
Can your Lordship take up this matter Friday on Thursday? Thursday.
No
Only
installment hearing at all. No installment hearing. We
Then your
have
Lordship can see this this judgment.
learned counsel appearing for the appellant panel counsel heavily banks upon the decision of Apex Court on State of Punjab versus Ranveer.
Another judgment I am doing.
We're making notes.
Yes, please.
And more particularly, some observations made in para 4 of the said decision in support of the contention that whatever be the reason by virtue of which vacancy in a post arises, the others in the list cannot lay a claim to that, and that they should go for fresh recruitment process. Okay. That's next decision.
Then the Nabin Kumar Jha,
Yes.
Rakhi Rai and others.
It says what?
Versus High Court of Delhi and others. The 2010 Volume 2 SCC, page 637.
They refer to Malik Bajar also. Malik Bajar was a matter relating to court recruitment.
Look at para 7 and 12, waiting list cannot be used as a reservoir to fill up vacancies which come into existence after issuance of notification advertisement. So that 7 and 12 is opposite to.
Where is the waiting list? Where is the waiting list? Where is the waiting list?
Waiting list.
Huh. It is in the same list.
We have not prepared waiting list.
Therefore, the judgment will not be applicable only.
The problem.
Had you prepared the waiting, a decision is an authority for the proposition it lays down in a given fact matrix, not for that which will logically follow from what has been so laid down.
That my submission with your Lordship, that once we have made the appointment and the selection committee has recommended one name only, and on that basis the appointment was made, and the other two persons have not recommended.
Kindly add that you advertise for one post only.
Look,
Selection committee could not have appointed 5 or 6 or more than one.
Single post appointment.
That one appointment. So that's so.
and other two persons who are the eligible or who have been shortlisted, they were not recommended by the selection committee.
Correct, because there was more meritorious candidate.
More meritorious candidate.
Correct. That candidate goes.
Yes, ma'am.
Then to whom it will go?
But that candidate goes.
Yes.
And the other two persons who are in the list, they were not recommended by the selection committee. So therefore, the selection, once the post became vacant, after his appointment was cancelled, again the selection committee will start, the selection process will start from that stage.
As between these two.
As between these two.
Para 7
There is a judgment.
Mr.
There
Sahoo,
is a judgment.
Mr. Sahoo,
Instantly I could not produce before your Lordship.
After Ranveer, let us go through Rakhi Rai.
Yes.
Para 7, Platinum A.
Firstly, there is no additional list.
Sir, it is answered there in Para 7.
Para 7.
It is a settled legal proposition that vacancies cannot be filled up over and above the number of vacancies advertised, as the recruitment of the candidate in excess of notified vacancies is a denial, deprivation of the constitutional right.
Yes, ma'am.
So that applies to your case also. You could not have recommended more than one.
So,
Your negative contention of harping, that since we did not suppose you would have recommended more than one, then this annexure 4 goes. Entire selection. So that was the discussion with Mr. Sahoo, younger Mr. Sahoo.
Miller, that
Suppose your contention before the learned single judge, any of the stages, right in the writ appeal also, annexure 4 is declared invalid by you subsequently or by the court, then the argument that would surface. Whether that is valid or law legally, that's another thing. Raghbir Sharma, Rakhi Rai, they itself laid down that law that you could not recommend more than this advertisement.
more than 1 million.
So now you take a stand. We could have recommended more than one. We have not recommended.
No, that is not my stand.
Correct.
That is not my stand.
Absolutely correct. You could not have recommended more than one. There is no question of select list, panel, or rule coming into play where it interdicts the life of the select list for 1 year or 2 years, whatever.
We could not have recommended more than one. This is my submission. Entirely, your lordship is correct in saying that.
We have understood. We have already.
Once that recommendation, that is the recommendation by the selection committee. The selection committee had not recommended the name of Abhijit Patnaik.
You have said it about half a dozen times.
Yes, ma'am. So therefore, that is my submission. And in support of that, I am just relying on those two judgments, ma'am. And we have also issued, the lordship can see Annexure 10, we have issued the notice to both the candidates.
That you should have done with
People appear before this election.
because you could not have rewritten para 7.
Your lordship can see, if your lordship will go meticulously to the judgment of the
writ petition doesn't refer to Sahoo. Here there are so many Sahoos, including me. It is between Patnaik and Biswal. You have invited Sahoo into the picture. That liberty you should have taken from the court. That para 7, because you went on, if you are in appeal of the single bench, you invited everyone. Then Mr. Sahoo. Then why not beyond these 3 candidates? If you are undertaking the selection process afresh, they are at the top.
Yes, ma'am.
They are only interviewed. So why not the other candidates? If your argument, because Rakhi Rai,
Yes, ma'am.
Rakhi Rai says that if you go on, then it is 16(1) and 14 violated for other candidates. Your approach is that you are discriminating against others who failed also.
No. This is
Up
not
to that, because then Mr. Sahoo, you are saying in the fresh selection process you will only conduct interview.
No. We have issued the. Your lordship kindly see. Your lordship kindly allow me to place only paragraph 8. Paragraph 8 of the earlier judgment.
One request we have.
Yes.
We should also see those who have been waiting in the queue.
Yes.
One case, we can, in 1986, Supreme Court said, LIC of India versus Escorts Limited, fix the time for argument. Otherwise, you will decide only one case, where the rest of the people should answer to their claim.
Then
we have, we are not coming in the way. You have argued, we will treat your point. This is only a request we have.
I am only requesting that paragraph 8, I may place.
Read.
Paragraph 8.
Read.
In the instant case, at page 35. At page 35. In the instant case, the recommendation of the selection committee was made on 1/4/2025, enclosed at so and so. As already stated, the present writ petition was filed on 28/3/2016 before expiry of the period of 1 year from the date of recommendation. There is now, however,
That he placed.
the panel as such. Nevertheless, it is not disputed that the opposite part number 8 was terminated from service on the ground of playing fraud, for which his appointment has to be treated as invalid from the very beginning. Under such circumstances, 2 other candidates who are called to the interview can raise a claim for being considered in the vacancy so created. Be it noted that merely because the petitioner was called to attend the interview does not confer on him any vested right of being appointed. Nevertheless, in view of the peculiar facts and circumstances obtained in the case vis-a-vis the selection and termination of service of part number 8, the case of the petitioner can at least be considered against the vacancy. This is being said because the earlier selection process cannot be said to have been validly concluded in view of the termination of the opposite part number 8 on ground of fraud and misrepresentation of facts, etc. For the foregoing reasons, therefore, writ application is disposed of, directing the opposite part number 2 and 3 to consider the case of the petitioner for selection. The court has not directed that you straightway give appointment to him.
Kindly, since you are reading it, I'll point out something that how you have rewritten it. Just again go to that para page 36. Para 36, what you are reading now.
36.
Yes, younger Mr. have also placed that.
Yes, ma'am.
See the last 5 lines.
Yes, ma'am.
The case of the petitioner, you have added another person. You are not getting it. That is what you are now placing.
Yes, ma'am.
6th line from
the case of the petitioner,
you have added another person there. Then kindly read full stop. Then kindly read. This is being said because the earlier selection process cannot be said to have been validly concluded. You have replaced concluded with done.
Yes,
you have set aside the entire process. Those liberties will be discriminatory as far as other candidates who failed, because they could have succeeded also. Now what you have done, Mr. Sahoo has placed that 3 stages of selection. You have, by interpreting or modifying on your own the court order, the last stage of selection of interview, you are going to redo it, which is only 30%. Look at that selection process which he was relying on. Parachute. Page 2 or annexure 2 about?
Annexure 2.
Annexure 2 is not that. Pretty much. What younger Mr. Sahoo is submitting, final merit list will be based on marks secured in first stage and stage 2 plus career evaluation. 1, 2, 3 you have obliterated. Now you are inviting
personal interview 30%.
30% for 30%. Again, you are inviting both the persons. You have interviewed other Vishwan and given him less marks. Then kindly mark the last line. Candidates who will qualify stage 1 and stage 2 will be considered
together. Will only be considered for personal.
So that again goes for a spin, because you are only pointing out one person to be interviewed along with him, which is it your case that Vishwal was not interviewed earlier? You see how much irrationality and arbitrariness you are bringing by that. Court has never used the word by consider all the persons. Court has never specified consider only interview. And the case is very simple. Page annexure 4 is that. Can you again go back to annexure 4?
Yes, ma'am.
No, we will not spend so much time for this on them. Fraud vitiates everything. So the person who had perpetrated fraud is out of the scene. If that is so, only 2 persons will remain. And client of Mr. Rathod will be the best amongst the 2. Otherwise, the doctrine of fraud vitiating everything will not have meaning at all. If it vitiates everything, that candidate is completely masked out and then will remain 2. Eventually, you cannot go on one more interview as between that 2.
Not interview. Not interview. We are not conducting a fresh interview.
No, selection.
Selection
process. You cannot do because that is already accomplished.
So then only we are relying on those.
Your answer is that, Mr. Sahoo. Then you have given him 48.17, Vishwan, and Patnaik given 51.17.
Yes.
Can you redo that to alter 48.17 and 51. Because you see the difficulty is that since you are raising this contention for the first time, we are trying to address your contention because you are raising it for the first time.
No. Factually, I have not placed one other thing before your lordship. This, we have issued a general notice for consideration, general advertisement. That advertisement was challenged. The Honorable Court said, when setting aside that advertisement, the second judgment, the Honorable Court said that you should confine between these 2. You should confine between these 2. That is at page 43, my lord. Thereafter, we issued this notice, my lord.
You see that.
At page 43, I am just bringing to your lordship's notice.
No, in fact, I already have answered you that this gave you a carte blanche, as it called, that to reopen the entire thing, issue advertisement, invite everyone. Whereas on your own, you say that Annexure 4 is validly done. You are giving a second lease of life to all the candidates, along with Biswal and Patnaik, who is prosecuting his litigation here.
Yes, my lord.
So is it not irrational and arbitrary?
So therefore, the court said that you should give your consideration only these two.
We'll consider.
We issued the notice.
Yes.
On that.
Let us see what he says.
By just saying that truth is half said, my lords will kindly consider.
Grab that mic.
I'm sorry.
Yes.
Lord, I begin by saying that truth is half said here. Lord, why I say so? Two submissions only I take an exception. Lord, my learned friend Mr. Sahoo says that he did not call for an interview at the last chance. They wanted a selection. He said it. Now just see, my lord, that Lord, I'll request both my lords to see the single judge writ petition, because in the writ appeal, all the documents are not filed. The writ petition.
35486.
My lord, the last writ petition, my lords, I'll pray my lords to see.
Earlier petition.
My lord, WPC 35486. So grateful, madam. Kindly take up this writ petition, madam. All the records are here. The writ appeal doesn't contain all this.
My lord is having, I'm also having.
Right.
So kindly refer to the page.
Now, my lord, kindly see that very annexure 1. But just a submission was made, annexure 1 of that single judge writ
Page
petition.
70.
Page 70. I'm so sorry, madam. Page 70.
So our assistant, he's a little bit slow. I mean, he doesn't understand the writ petition, so he has to respond.
My lords, just now it is said that they are not going for a fresh interview. Just see page 17, what is the letter that was impugned before the Honorable Single Judge. It is for a personal interview. Kindly see, madam. Tarawan. But not only this, I'll point out how many wrong submissions are made before my lords, on fact also. I'll point out how many wrong submissions have been made on facts also.
And where is Bishwan?
Avinash Biswal.
Yes. He's not there in that 17 letter. He's not also asked.
Avinash Biswal who played fraud.
No.
Yes.
Avinash Biswal.
Sahoo and Patnaik, sorry.
It is like this now. Now tell me, let me tell one more just factual aspect which my Mr. Sahoo is not saying. After the judgment was passed by this Honorable Court for second time, they forced me to appear a fresh selection process. What is that selection process? This selection process is technical assistant video editing. Am I clear, madam? Technical assistant video editing. Now, after suffering the judgment, they published an advertisement only for technical assistant. Not the same post. And they compelled me to appear in that interview. So therefore, I was forced to challenge that order, the advertisement in this Honorable Court. Now, your Lordship may see, that is the reason this Honorable Single Judge intervened in the matter and directed them to confine the selection process within these two. Then what they did, after this fresh selection was set at not so far as the petitioners are concerned, they issued me this letter to appear in a fresh interview. My lords will kindly appreciate. This is an advertisement of
a different post.
Yes.
No.
Kindly see. No, not for different purpose. Personal interview for video editing. The advertisement which they are referring to fresh selection, that is
set aside, you are saying.
Yes, not set aside. Not set aside.
Not set aside.
No. It was not set aside. They were free to go ahead with that selection process. But we were protected, saying that don't force us to appear in that, because that's not the same post for which you have been fighting. Kindly similar, apart from that, this is a selection in the year 2015. Not what you did, you appointed a person who is nephew of your own registrar. That is my specific case on affidavit. The NIT's registrar appointed her own nephew, this Biswal, who obtained a fraudulent certificate from West Bengal. And this whole process to be unearthed took 6 years' time to them. They went on protecting that illegal appointment till my Lord Honorable Justice Sahoo intervened in the matter, sitting a single.
Is it so?
Yes.
So should I take this up in return?
A different matter.
I'm sorry, I have forgotten.
That has attained finally. Even otherwise, it has attained finally.
Yes. So your Lordship can take, no problem. The Lordship has
I
not.
have no objection for the recusal of my brother.
No. What they did before your Lordships, they filed an affidavit. Can you see that affidavit?
We have understood that. Yes. Keep it. Kindly be seated.
No, what my London friend is saying, making an aspersion on me.
No, we are not making that at all. Be assured.
I have placed the wrong fact before your
No,
lordship.
be assured that
Sir, don't take
it
it
will be
personally.
discovered.
That is not correct.
Are you client, sir?
We will not.
Referring, I'm not client. This here said
Your
that
client
Mr.
is-
Sahoo has placed the false fact before the court.
No, we don't agree with him.
What is this?
We don't agree with him. See,
But
sir,
first
Mr.
advertisement
Sahoo
was there.
Mr. Sahoo,
Yes, ma'am.
we earlier advocacy, you have seen wipers were there to wipe our eyes because advocate used to cry with emotionally. If you read Roman history, you will find that. Cicero mentions in it 12 tables. Now, generally, we are a bit lavish in our arguments. We take that liberty. Now you are quarreling before us. We know that we will go together to coffee shop, leaving the judges here.
That's there.
No.
That's
my eyes.
After all, the English is a foreign language.
No.
And in Orissa, it is too foreign.
I think Mr. Sahoo would
Much
be
less
an
foreign.
exception.
It is just-
We have best of
It
relationship.
is just statement.
Anyway, you
in the context
also-
of this case, my lord.
No, but we understand. He said that. It's not a personal aspersion.
No.
No, not at all.
These are the
I
submissions.
haven't made.
First
We
advertisement
sometimes,
was made. After the judgment was passed, first advertisement was made.
we have heard it.
Technical assistant, video editing is a branch, my lord. Technical assistant is the post.
We are not going to that. We are on a different point. We will just give it. Kindly be seated. You have assisted the court more than we expected. It was a over assistance. Kindly be seated. Even youngster did very well. Kindly be seated. Kindly be seated. We are just making the notes. This is not the judgment. But we are not interfering. This one. The writ appeal is dismissed on the following grounds. After the selection process having been done, 3 were shortlisted, and of them, 2 were not recommended, and only 1 was. First off, the said one having perpetrated fraud, his appointment came to be set at naught. And in that relation, there was a WP number so and so. First, learned single judge has a reasoned out, and we agree with that fraud vitiates everything. Why can't you sit down? No chair. All right. We agree that fraud vitiates everything means fraud vitiates everything ab inceptio. And therefore, the recommended candidate goes out of the list once for all. 7. If that be so, the next meritorious candidate is none other than the private respondent herein, who has to be accorded the appointment in question. First, next paragraph. The vehement submission of Mr. Senior Sahoo that once the list is operated, rightly or wrongly, and a person is appointed to the post in question, the eventual vacancies subsequently accruing cannot go to the benefit of those in the list below or in the additional list, regardless of their merits. First of all,
because they were not recommended.
It is more so because, according to him, it is more so because they were specifically not recommended. First, in ordinary circumstances, arguably, we had agreed with the same. First, here is a case of fraud, and therefore, the decision cited by Mr. Sahoo in State of Punjab versus Raghuveer Chand Sharma, 2002, 1 ACC 113, more particularly paragraph number 4, does not come to these aids. First one. Many other contentions were urged before us, and we do not think that all that is necessary, since the contention we have treated above happens to be the jugular vein of the case, and therefore they are not treated. Writ appeal dismissed. We will be failing in our part if we do not put words of appreciation for the performance of Mr. Senior Sahoo and the Junior Sahoo and Mr. Rath, ably assisted by Mr. Now, Changalavara and Naidu versus so and so. Okay. That's a good thing.
I don't know that.
Yes, this is only a draft of our note. Yes. Okay, order we have filed. Yes. That writ appeal is negative. Yes. And we should go with a smile.
Yes,
yes. Yes.
We should get the satisfaction that we have presented our case.
That's what. That's what. That's what.
That's what I can do.
Yes.
Appointed on contractual basis. The first show cause notice was issued against the proposed disengagement or alleged misappropriation of government funds. I submitted my show cause. Then I was placed under suspension pending trial of a disciplinary proceeding. No disciplinary proceeding was ever conducted. And a second show cause notice was issued, followed by the disengagement order. I challenged that order. And the Honorable Single Judge holds that since two notices were issued, disciplinary proceeding is conducted as per procedure, and the writ court is not the fact-finding court.
Two notices are exchanged.
Yes.
That itself constitutes inquiry.
Yes. That is.
What was your reply to the notices?
My reply to the notice is, I disputed the allegations that I have never misappropriated. Annexure 2 to my writ petition. Annexure 3.
The 3.
Page 12 of the writ petition.
What happened to criminal case?
I have been acquitted.
Is it honorable acquittal?
Yes.
Read a few sentences to say it is honorable.
Yes, yes. Because that could not be produced before the Honorable Single Judge. but I have the judgment with me and I have taken a ground in the writ appeal also.
But your denial is, what is your educational qualification?
Well, I am a diploma engineer.
Diploma engineer. But language appears to be of a lawyer. Now, where is your first reply to the notice?
That is the Annexure 3 is the first reply. I said that since the criminal case is pending trial.
But although I am not in a position to know the basis of allegations made out in the report of so and so, so and so.
Because the show cause notice referred to certain report of the project director.
Did you call for those reports?
No.
Then?
I said I must be provided with that report because no definite charge was framed. The procedure of disciplinary proceeding was never followed.
You asked for report of that one.
I have said that in my show cause that I am not.
Yes, who appears for? What is that? Kashinatha DIXIT versus take out that judgment?
That copy has not been supplied. I don't have an office copy. This is for fresh admission.
Check out that judgment. Kashinatha DIXIT versus so and so. Where a delinquent employee asks for the documents, you are bound to furnish the documents. Which is that judgment, brother?
And unless you
Furnish, how we will
try to
be?
favor it, why will you rely on documents wise beyond his knowledge?
And he says it's an honorable acquittal also. Where is the inquiry? That misappropriation is a serious charge. And it will result into the serious penalty also.
Major penalty.
Major penalty. So where in case of major penalty, without inquiry, by exchange of just shooting the letters and replies, that is no inquiry at all. Which is that? Take out that judgment, brother. Which is that judgment? Do you have that judgment, sir, with you?
No, lost on
Kashinatha DIXIT versus so and so. Maybe DIXIT, it may be AP, etc. Issue emergent notice. Learned Supreme Court. Learned AGA, Mr. Mohanty is requested to accept notice for the respondents. Kindly share copies.
Yes.
Judgment, sir. That may help you.
211. 211.
Call after 3 weeks. That's the only point. Okay. Yes.
Your Lordship, pardon to make a mention. A sincere request on my behalf in item number 5. Your Lordship, a recent time period may be given to comply with the. Your Lordship, since declined to interfere with the rate appeal, the recent time period may be.
Implement the order of the single judge.
Your Lordship.
Within a period of 8 weeks.
Your Lordship, a time period may be taken to take a suitable decision, Your Lordship.
Not take a decision.
As per the.
It will be an order only. Again, they will come before the court.
Your Lordship.
If we write consider, it will never be considered in accordance with law. Other considerations start. Section 2E, something like that, consideration of Contract Act. Not this consideration. He was related to registrar himself. Yes.
Item 7. No, compliance for lordship's order. This is second contempt notice.
Second contempt. First contempt was dropped earlier.
No. That was again directed for reconsideration. That was also not complied with.
In contempt, this direction.
No, this is the practice here in our High Court. First contempt, second contempt, third contempt. My client has reached to this second stage.
Yes, brother. Who appears for the?
Since for the SBI matter.
State Bank of India.
State Bank of India.
Notice.
Issue police notice to to the contempt, to the, what they call this, accused or contemners, what they call
Contempt.
Opposite party alleged
Opposite parties are
alleged contempt.
it is contempt. But after charges are framed, they become contempt.
If they find so-called and rejected, they become contempt. State versus so and so.
Issue police notice, emergent police notice to the respondents. Stroke, contempt, returnable within 2 weeks. Unless contempt is tough, how the dignity of the court will remain?
We are suffering that, Lord says. Order is not complied with, again the direction.
Again direction, one more direction.
Item 8.
May I please, Your Lordship?
Here before the court on the next date of hearing. Call this matter on, give some date.
You file requisites within 3 working days.
May I please?
But item 10, I'm appearing on behalf of Mr. Rupesh Kumar Hon'Ble, Counsel for Union of India. In the morning, you mentioned that you're suffering from severe fever.
You want time in this matter?
Yes, Your Lordship. Any convenient that
Can we give the time?
But what happened? We did what the ground of illness is like. What happened? For a minute, what I'm saying. It was listed twice. Litigation is since 99. Went up to Supreme Court. Again, it is in second round.
We will fix a date.
Yes.
That date
because
will complete.
it's a land outage of railway who wanted their appointments. Honorable Supreme Court gave 15 years relaxation because of the lengthy hearing. Now that is the urgency. There is a date which is as early as possible. So
All are served in this matter.
I have already, my name is not appearing. I have appeared through cabinet.
No, for respondents.
For all the respondents.
All respondents are served now.
You are appearing for all. So
All are
cabinet-
cabinet respondents.
So cabinet has been discharged or you are yet to get a copy?
Cabinet already served, they have not given a copy.
Yes,
Then in the court, they gave the copy. They gave the copy last occasion on being inquiry. Therefore, already service sufficient. We have appeared.
6th of August 2025. Finally, at the request of learned CGC,
Senior Panel Counsel.
Senior Panel Counsel appearing for you.
Your name?
Dipandita Naik.
Dipandita Naik on behalf of R.K. Sahoo, Senior Panel Counsel.
Okay, come.
R.K. Kanungu.
I only want a earlier disposal of this matter, and on that also it can be taken up.
Item 11.
Okay.
May please, Your Lordship.
This matter is similar to other nursing matter where the prayer is
We have posted to 17.
24.
24, my lord. 24.
Show emergent notice. First in the
Milord, I will serve requisites number of copies, Milord. My learned
Copy has not been served.
no, who are the respondents?
Well, respondent, government of the respondent, I have already served the copies, sir. Government of
Who
Odisha.
is appearing?
2 and 3, my lords. 2 and 3 is myself.
1, 3 is Mr. Mahanti.
2, 3, and 4. Director of nursing also.
Director of nursing, I am not appearing. Government will appear.
I'm sorry, government is there.
1 and 4,
Government.
AG.
1 and 4.
2 and 3,
2 and 3.
Arshimant.
adequate number of extra copies shall be
Mirror.
served during course of the day. List on 24th of July 2025 when similar matters are listed. On which day similar matters have been directed to be listed.
yes.
12.
As per the police investigation report, in the meantime, the person as the expert, so far the accused person is concerned, on 6/1/2021.
Accused is dead.
Provide that copy to us. It abates.
Yes, but it's a leave not granted. This dismissed leave petition is managed. It will be recovered against it.
The proceeding itself awaits on the death of the accused. Sole accused.
Sole accused.
Record that it will be. Learned AGA cum public prosecutor submits that the sole accused having passed away, the appeal statutorily abates in criminal jurisprudence.
First, the report along with you please file a memo along with this. The memo.
Along with the memo, it will be part of
the record. Shall be kept on record.
Ordered
I've
accordingly.
taken note of it. I am filing with the member.
Already ordered it pass.
Ordered accordingly, and the appeal is dismissed.
Item 13.
My lord, the sole respondent is avoiding to receive the notice. My
This matter has been remanded from the Honorable Apex Court, madam.
Yes.
And Mr. How many matters?
My lord, from this order, 2 matters are remanded.
Any similar matters?
2 other 2 matters are pending.
So give it in a piece of paper. So
We'll call all those matters and pass on common order.
No, in one common judgment.
Common judgment.
Honorable Single just passed in one common judgment.
common judgment in
respect of 4 writ applications.
So that judgment is enclosed here.
Read copy has not been writ applied.
No, you should look at the read copy. You are the petitioner there.
No, my lord, in read appeal, government file read appeal, my lord. Read appeal was dismissed on the ground of delay.
That is how I'm asking you that which of the read petitions the Lord Single Judge disposed of. That
Yes.
I wanted to know from.
My lord, that is two five eight two one. 25821.
Page 20, my lord, details.
Page 20.
Page 20.
No, what we are thinking is, we'll pool similar matters.
Similar.
You give list of the other matters.
See, here is referring page 20 all matters.
My lord, page 20 and 21.
See, it is singular.
So then,
Then the read appeals. How many read appeals out of this you have filed?
They filed 4 writ appeals.
So today how many listed?
Single one.
That was remanded from the Honorable Apex. And in Apex Court, my lord, 2 cases are remanded. That is in order. That is SLP number 9533 of 24 and 9334 of 24. That relates to.
I think you are missing one page or top of it. Because it is now.
My lord, I have given certified copy, man.
Certified copy at?
Flag X, my lord.
X.
we can tell the registry to post those matters along with this matter.
The registry shall place on record read appeal number 2688 of 2023, 2688 of 20, the same number. Other read appeals, Mr. Mahanti?
Other writ appeal, my lord. May I see that?
No, just kindly pass it over. Let them find out the proper page. Supreme Court side took proper page ta kadi diyo.
Flag X marking. That is flag X.
Flag A.
X.
But flag X refers to only one writ appeal 2688.
You can give the number of the writ appeals. Your own writ appeals.
My lord, I'm only one.
In one. Other matters are, which are other matters?
Others, I will give the details.
Yes. Well, call this matter.
May I transcribe? So the order.
Whole order is there.
Yes, I have given the detailed certified copy.
Anyway, matters are remanded.
Sir,
Nothing more has
sir,
happened.
kindly find out in that certified copy
My lord,
which are the writ appeals.
That's all.
Because if you cannot find out, I cannot also.
my lord, only
So that I have been telling you.
my lord, in cause title only one.
So I have, in fact, I was dictating that. But then I stopped that. Which are the other writ appeals?
My lord, 2688, my lord.
Yes,
Then 2689.
2689.
These two matters are remanded. Another two matters, my lord, that is pending before the court, my lord.
You don't have number of that?
Please
Yes,
tell the
yes,
number.
Give that number. Write down and give the number.
2687 and 2691.
Which year, etc. Just write.
23.
Sir, remanded is 2688 and
2689.
2689. Remanded by the apex court in SLP into bracket C 9533 of 2024. Stop.
And 95.
That's just. It is also stated by the learned counsel appearing for the respondent that other two writ appeals, that is writ appeal number
2687.
2687 and 2691
Pending.
pending. Registry shall list all the writ appeals together. On 6th of August.
Correct copy maybe.
Again?
Of 20.
Yes, yes. 23. All are 23. All are 23, Mr. Misra.
All are 23.
Delays there of 183 days.
That has
Supreme Court has said that
Apex court just decided on merits.
a copy of the rate appeal may be targeted.
Kindly extend the read appeal.
By tomorrow, I will.
Knowledge.
Item 16. That's a note, my lord. No, notice return on sub, my lord. Address is left without instruction.
Sorry, that will be affixed in the his residence, in the her residence.
Per residence.
Yes,
Affixed. The postal tracking says left without instruction.
lords, may
Whether
paper publication.
fixed phones, do they require photographing them? Just saying fixed.
Now, sir, it has been modified for photography. I think so.
They're
I'm
not
not sure.
according to that, yes.
Yes, my lord.
Sir, kindly write it down because there are a lot of confusion.
They ask you to write down.
write them.
Well, the Supreme Court pending.
They are still pending before the Supreme Court.
Yes, ma'am.
Okay.
My lord, 268791 pending before the Honorable High Court.
No.
It has been rectified as pending before the Honorable Apex.
Two more are pending before the apex.
2688 and 2689 already remanded by the Honorable Apex Court.
Yes, that Mr. Mahanti agrees. You are not. He agrees that, but the other two which you said that still pending.
High Court.
So Supreme Court. So he will check. You please check it that because you have filed the SLP.
No, I will check it.
Just repeat. Well, let him take fresh notice in terms of new rules.
So what are the rule of affixture? Do they take photograph?
Otherwise, you nobody knows.
My lord, it's an intra-court appeal having the delay of 161 days. And on the first day, when without giving a chance, my lord, this order has been passed, keeping in view that regularization of Uma Devi, ML Kesari and
How many years of service he has put in?
32 years.
32.
since 93, you know, as a
93.
DLR.
93 to
Till that time.
till date still serving only.
Yes.
Regulation is with effect from which date? Looking to consider.
To consider.
Consider. This intra-court appeal by the state seeks to call in question a learned single judge's order stated so and so, rendered in WP number so and so, whereby a direction has been issued to the appellants herein for consideration of the case of the petitioner for regularization in service. First, next paragraph, learned AG appearing for the appellants seeks to submits that the order of the kind could not have been issued in view of the decision of the apex court in state of Karnataka versus Umadevi, followed by ML Kesari. First, learned counsel representing the respondent employee resists the appeal, contending that his client has been working since the last
Since
1993, and thus he has put in more than 32 years of spotless service, and that would entitle him to the order of regularization. First, next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge and also the submission made on behalf of the employee by his learned counsel. First off, if a person has worked for 32 long years, it would not augur well to the appellants herein to say that they would not regularize the services of such persons. First of all, the very fact that more than 3 decades the employee is permitted to work, is continued in service, goes to show that there is a requirement of his services. First of all, next paragraph. In the above circumstances, this appeal being devoid of merits is liable to be accordingly rejected. The order of the learned single judge shall be given effect to within a period of 8 weeks. Public search.
Let it be 3 months.
3 months. 3 months.
Item 19.
3 months, all right, but report compliance to the Registrar General of this court. Otherwise, one more contempt will come. The order of the learned single judge shall be complied with, and the compliance report shall be filed with the Registrar General of this court within an outer limit of 3 months. Mr. Mohanty, wherever you have challenged similar order, these are the orders to pass orders. Is it not? Yes. You have to consider all contentions are kept open.
Now, only in that case particularly, on the hard day, at the threshold, we have not been hard.
So have you been prejudiced?
We are saying that so far this DLRs are...
So the court has not said that you convert DLR to what charged or whatever.
Only said we consider
any opinion that they are treated to be equal as what charged and
judgments only.
One more sentence. Mr. Mohanty submits that learned single judge ought to have given a reasonable opportunity of meeting the case of the petitioner, and that having not been given, there is violation of principles of natural justice. Next paragraph of citation, having heard, etc. The submission of learned counsel for the AGA, learned AGA appearing for the appellant, that the opportunity was not given to the appellant, and that the matter has been disposed of at the admission level, arguably may be true. First off, however, that would not come to his aid in as much as the order is to consider the case of the respondent employee and nothing beyond that. First off, therefore, all may be reflected. Order which the appellant is directed to pass in respect of the claim for regularization. Next.
19.
Yes, is the same to item number 18, Millers. In the first day, Millers order has been passed without given an opportunity. That is work charge employee, Millers. And that is honorable single judge directed to consider the period of NMR and work charge period for calculating the minimum pension, Millers.
18
yes.
Judgment of
Yes. This intra-court appeal is by the state. Full stop. It calls in question order of the learned single judge in respondent employees WP number so and so, whereby a direction dated so and so has been issued
15/1/23.
considering
5/10/23
for regularization. First, next paragraph. The subject matter of this appeal is substantially similar to the one.
Here is Millers. He has regularized in the 2022. 22 Millers.
He has been regularized.
Yes.
In 2022.
19/8/22.
He has been regularized.
Yes.
But what was that case for alteration of the date?
No Millers. He has Honorable Single Judge directed to take a period of NMR for qualifying of the calculating of pension Millers. That is work charge. Yes.
Work charge just then because under the sub rule 3 of rule 18, we have to take full.
Right, Millers. Look, but Honorable Single Judge has said that qualifying service. But from the period of taking into account of work charge period and as well as
Mr. Mohanty, what is your difficulty?
Recall that one. It is in your favor. In fact, we would have allowed the entire period to be counted because of Sudhanshu case that
this is state favor. Sudhanshu Jana case.
Yes.
Because here is a case Millers, he was brought over the work charge establishment in 5/10/2010.
5/10/2010.
He has regularized on 19/8/22 Millers.
19/8/22. But read sub rule 3 of rule 18.
When he has retired?
Yes.
Or he is yet to retire?
On 31st December 22.
But we have held.
If you add the qualifying service, I think that subsequent notification is there also.
It's not question under 18.
Section 18(3) is
full service has to be counted. Once it is regularized. No, he's work charge only.
Singular directed to consider is NMR.
Mr. Mohanty, after adding work charge, is there any shortage?
Yes, I think shortage.
Qualifying service.
Yes.
5/10. He says
2010. 5/10.
Because your facts are
there is a
clear.
shortage.
How much shortage?
23 years. 5/10/2014.
Notice has to matter. Let us issue notice because the NMR etc. You are saying we are not very sure of that. Issue emergent. Recall that order. Issue emergent notice. Okay.
First, Millers, I have
take this.
Let's stay. I have filed a IA Millers.
File stay also.
Yes. IA number 6291.
Entry model. Staying the impugned order, impugned judgment is granted till next date of hearing. Okay.
Item 20.
Since there are arguable points in the light of rule 18(3) of 1992 pension rules, and also the apex petition in Sudhanshu Jena. So just get this. Yes,
there is delay of 150 days, Madam.
Delay of 150 days?
Yes, 150.
On merits, what we have got?
Well, in fact, the implement is Annex 2, Madam.
The 2?
Yes.
When you are putting flat to the order, you put flat to everything. Yes, sir.
Annex 2, Madam.
Page number?
Page, running page 114.
111.
114.
14.
Running page, yes. And paragraph 5.
Yes.
So the petitioner, in fact, being a widow of the government servant, had applied for compensation of 50 lakhs under the Pradhan Mantri Garib Kalyan package, as because he died during COVID period. And a scheme was floated that is called Pradhan Mantri Garib Kalyan package.
whoever dies due to COVID-19, the dependents will be getting prophylaxis from the Krishna.
Where is that scheme?
That scheme is there, no?
To us, we do not.
Yes, ma'am. It is there.
50 lakhs.
Yes, ma'am. Yes.
Page 89 bills. Page 89 of the
88, page 89.
It's made for the health worker. Then second 90 page 90 is the eligibility criteria for getting other persons.
To others also it is extended.
50,000 to the extent of 50,000 items to the
50,000.
Yes.
50 lakhs.
Yes.
50 lakhs is the for the health worker
workers.
insurance. He is not a health worker.
Yes, ma'am. Whether he is a health worker or not, that is to be decided. On the basis of the wrong submission made by the Learned Council for the state, this order has been passed.
To show prima facie that you were a health worker, the DC was the health worker. Where is the material?
Yes, ma'am. Page 70. In fact, compensation was not given. As there was a dispute whether he died due to COVID-19 or not.
That is one aspect. We'll assume that he died due to COVID now.
Yes.
Show that you are the health worker.
The page 89 says who is the health worker?
89. Health worker is defined.
Yes, eligibility to
any person engaged in COVID-19 related work drafted by government of Odisha or any of its agencies. We are not eligible for insurance coverage under the guideline of India. So is eligible for such financial assistance to be given to their spouse or next of kin. It shall cover the following categories of personnel engaged in COVID-19 related duties by government of Odisha, employees of state government, urban, rural, so and so. Any private person or volunteer, elected representative, any person hired by government or enterprise agency through a professional agency on contract and daily wage. Mandatory condition. Where is the material to show that you fall into number 2? Any private person?
No, I am government servant.
You are number 1.
Yes, sir.
Employees of state government.
Yes, ma'am. Assistant engineer in public health department.
You were assistant engineer in public health department.
I was on duty. There was a dispute whether I died within 30 days of
being infected or died was positive.
Yes, that was
is it a criteria that somebody dies beyond 30 days of being diagnosed?
That was the criteria made there.
Because suppose if they do not take proper treatment, then they die. For them, if you are vigilant, then that way. The accused person
here he has been reported in different hospitals.
But the government took a different stand, the authorities. But the order has been passed on the basis of the statement made by the
government is saying that he is not a health worker. On what basis you are saying that?
Let's say working as a assistant engineer in the office of the
employees of state government.
Lordship, prior to that, Lordship is page 89. Guidelines for PMGKP.
89.
89 clause A.
Read.
Coronavirus diseases COVID-19, which is caused by the new virus, such is playing havoc in the entire world. WHO has declared the...
No, that's all story.
That is to give further. To give further memorandum to the India efforts to fight COVID-19.
Which page you are reading?
Miller's page 89.
89.
Yes.
Scroll to
Very important is Miller's third line.
89, there are 2 pages. One is rounded of 63. Another is 89 unrounded.
62 Miller's, that is rounded in 62.
Rounded 62.
Yes, 89 page. That is guideline dated 27/2020.
Correct.
Yes. To give further momentum to India's efforts to fight COVID-19 and assure our doctors and health workers that their well-being is foremost for the government. Government of the India by DO number such and such announced that Pradhan Mantri Garib Kalyan Package Insurance Scheme for Health Worker that is important, for health worker fighting COVID-19 to provide an insurance coverage of 50 lakhs for a 90 days to a public health worker provides including community health worker who may have been direct contact and care of COVID-19 patient and who may be risks being impacted by this. Also on account of unprecedented situation, private hospital, staff, retired voluntary local urban bodies contact daily wage.
No, eligibility says he must be a government employee. He is, whether he was drafted by the government for COVID-related work.
Yes,
Where is the order that you should go and work amongst the people, you should give a mask, you should do this, that, etc. Where is that? You may be government employee.
Yes,
but unless you are drafted to COVID-related work, you are not entitled.
Page 71.
And,
7 months.
And Mr. Dasmapatra, this caption of Garib Kalyan, so I think it is meant for persons who are not covered with anything.
Anything. Yes.
But is it your case that you have not got anything, only this thing you are claiming, or you have got anything?
No, I have not got anything.
No insurance coverage,
No.
No, but you are in a well-employed position.
But pension and everything you are getting.
Then you are not Garib. It is for Garib people.
But other, my colleagues have got.
You should file case against the government for filing that.
That's what I filed.
No, a wrong decision will not give a right in your favor. You should show others have been granted and it has been rightly granted, therefore I cannot be denied. That equality. Not others have been wrongly granted and therefore I should also be granted. That is no argument.
No, I'm not arguing that.
Negative.
I'm entitled to.
Under what problem? It is Garib. Kindly see how the text of the title of the scheme is.
Yes, ma'am.
It is for Garib people because India is inhabited by poor people, though it's a very rich country. You do not fit into the very first idea, Garib. You do not fit into that idea.
And as it fell from my lord, that they have been drafted for COVID-19
You should be drafted, you should be taken, asked to do COVID-related duties. Then only
Yes,
it will apply to your engineer.
I'm coming to that point. I have been asked to do COVID duty.
Where is that?
It's,
There is difference between COVID-related duty. You are asked to work during the COVID period is one thing. You are asked to work in relation to COVID things.
Yes, ma'am.
That is required.
And the language is responsibilities directly.
Directly.
Yes, ma'am. It's page 51.
5.1.
Yes, ma'am.
Go to 5.1.
That is order dated?
24 February.
Yes, ma'am.
24 February 21.
Yes, ma'am. The executive engineer writes to the assistant engineer that you are requested to intimate the office the following information for taking for the external matter.
When the death occurred, perhaps death occurred before this letter.
No.
After this letter.
17/10/2020. 17/10/2020. That.
It must be. Otherwise, such letter will not be generated at all.
Therefore, it was being processed.
No, show us that your services were taken for directly for COVID-related functions. It must be some COVID-related function, and directly, not immediately. It should be immediate concern with the COVID. Then alone you are entitled to, not otherwise.
Yes, ma'am. Your also will come to page 42 then.
42.
Yes, ma'am.
From 51, you are not drawing any milk now.
42, ma'am.
42.
Yeah.
It is dated?
No,
Does it bear a date?
it is 23rd March 2020. I have been
March.
issued with on emergency government duty,
Government duty.
COVID-19.
During COVID-19, many will work. That's another thing. It was not COVID related. How COVID related duty? Where is the COVID related duty?
That guideline para seems to be just look at what you are placing. After the definition, 1, 2, 3, you come in 1. Just below that.
Yes, please.
Can you look at it? That is what being asked.
1.
Yes. See, mandatory conditions of eligibility.
Yes, please.
Kindly go through that. Place it.
The above category of persons will be eligible
Just speak to the microphone. Kindly speak to the microphone. Because there is also noise in the phone. So at times you are missing.
What's the mandatory conditions of eligibility? The above category of persons will be eligible for financial assistance under these guidelines, provided they fulfill the following mandatory conditions: that they are drafted by government or by its authorized agency to perform COVID-19 related duties, responsibilities directly.
Yes.
The contact of COVID-19 infection must be while in active line of duty, and the worker employee must not be on any kind of leave or leave from the duty, provided she is tested or detected COVID-19.
82 or 53, whatever. No, I'm sorry. I'm instructing you, so that creates the confusion. He's just looking blank. Kindly carry on. Our staff have instructed. 63.
May I?
Or you open the read petition. Straight away go to 60.
Now we are asking you one more thing. Did you get after death the DCRG, terminal benefits, such other things you got? Insurance?
Other government benefits?
Full government benefits have been received by you.
I'm not sure, but I might have received. That instruction don't have.
This is for Garib people. The scheme itself says
63, go to
it is for
63.
poor people who will not have anything to fall upon.
63, just below that. The next page. Stop there.
Eligibility. Person engaged in COVID-19 related work drafted by government.
What's it?
Regulation.
This one is
The above. That they are drafted by government or by separate agencies to perform COVID-19 related duty responsibility directly. While in active line of duty, and the worker or employee must not be on any kind of leave from the duty. 1 and 2, read 1 and 2. It is for health workers.
yes.
Exactly. Well, health workers, and that includes the persons who are directly. This eligibility, I'm placing reliance on eligibility criteria.
Suppose if your services are drafted for looking after the vehicle section during COVID, because vehicles will be required, we can't say that it is directly related to COVID. Otherwise, everybody will be related to COVID in one or the other.
My job is to, my lord, repair the hospital premises also. I'm public health department, working in public health department.
Did you do that?
Water supply. The problem is
Public
that
health.
how do you qualify 1 and 2?
Yes, my lord.
The contact of COVID infection must be while in active line of duty, as you just read now.
Yes, my lord.
And the worker employee must not be of any kind of leave.
Where is the certificate? Many contracted
That certificate has been issued, my lord. I died due to COVID-19.
COVID-19 death might have happened.
Yes.
You contracted this COVID
Yes.
during the discharge of your duties. Otherwise, many deaths have happened.
Yes, ma'am. During that period, I was in duty.
No, you have to show that because
Nexus
provided. Then read further the proviso.
Provided she is tested COVID-19
within 14 days from his or last day of active COVID-19 related duty. You should have contracted COVID during the discharge of duty, and that should be within 14 days of your engagement.
Yes, ma'am.
Otherwise, many have contracted COVID and they have passed away. For all of them, this is not the scheme.
Yes, ma'am.
And there is nothing. We agree with the learned single.
But while on duty, I died. That is the.
It is
I mean, being employed, you died. You were public health engineer, assistant engineer, public health, looking after water supply. That, but that's not the criteria. All the government employees who are in work. So unless you show right now that, or even now also in this petition, you have shown that you have satisfied B1, because Mr. Mahanti's objection that you are not satisfying B1, maybe we accept. But what about C?
What's your pass over? I'll just please. One pass over.
At 2 o'clock, you will be coming?
Yes, sir. After
Yes, sir.
ready one.
I will to mention minute item number 13.
1-3.
1-3 minute. I got the information from the petitioner that the
where we directed notice 14 days. Therefore, just look into 14 days. Therefore, just look into. We'll come after in the second session. You can mention about that.
Continue.
Item 44, I mentioned the
44.
The order 21 rule 11A issue. While they
Personal appearance matters is there. Personal appearance is there. 54.
No.
Which one is not personal appearance?
27, 36.
So, Mr. After the personal appearance matter.
Please wait.
item 13.
27.
Item 27.
Your memo you have mentioned, give it to the court master and make them mention the serial number of the item so that you can locate the file.
Item number 13.
Yes. Personal appearance. Party.
Item 27, personal appearance.
what the opposite.
We have to show two things.
Yes.
Number one, you are drawn for the COVID-related work. Number one. Number two, you contracted COVID in the discharge of your duty. And that was within 15 days prescribed in that sub-rule 2, subclass 2. And number three, you will fit into Garib, something you said, na? Some Hindi title.
Pradhan Mantri.
Garib Pradhan Mantri Yojana.
Garib. Yes.
These three things you have to show. These are meant for Garib people, not for gazetted officers like your client's husband, father, whoever, we do not know. So this, in this parameter, your case should fit. Why Garib is, if a breadwinner dies, there will be nobody to look after the family. Therefore, money is given. Is it not? But in the case of your client, if he dies in harness, he will get the terminal benefits. And widow or the widower, as the case may be, will get possibly the compassionate appointment also. So the scheme does not keep such people in its focus. It appears that way.
So I'll address the first query Your Lordship has raised. I'll only place 2-3 documents, page 50, the order of the Office of the Executive.
We are with you that you are a government servant,
Yes.
but no mandatory conditions of eligibility, those three conditions. Again, the infection, this incubation period they have taken, that post your exposure to the COVID patient, where you attended the COVID patient, you are tested positive after 14 days. The reason being, maybe it's scientific, but it can't.
That is,
Legally, it may not be deduced. You can't provided that.
Yeah, that is there. That is there, my lord.
So you have to show that you have satisfied those 3 criteria.
The first,
you were drafted by the government for COVID work. Second, that infection, you suffered infection by exposure while in active duty. Third, you are tested positive after 14 days of such exposure.
that has been amended to 30 days.
30 days.
yeah, 30 days.
Whether it is within the 30 days.
Guideline dated 29/7/2000.
30 days. It is there, admittedly
30 days. Clause C.
No dispute.
Then
No dispute.
Clause C has been amended to 30 days only.
30 days. Well, it's only page 50.
We don't want to see because we believe you, fully believe you.
That I was on
We want to
COVID
be
duty.
assisted by you that you satisfy these 3 things so that we can sit to him so that he can answer.
Yes, my lord. I'll satisfy that I was on COVID duty, COVID-19 duty, which is borne
What
out.
they say, they agree that you are on.
Yes.
You are,
Yes, my lord.
Yes, Mr. Bhanti, you say that you are drafted
Page
for
50.
COVID-19
No,
duty.
here the Miller's executive engineers they look after the PHE.
So they
Work.
dispute, Mr. Sir.
No,
That
my
is
lord.
not,
The document says so.
Not 60 that.
Page 50, let him answer page 50. Revert to page 50.
Page 50.
Then whatever the chief engineer, executive engineer, so is the COVID duty. Chief engineer also passes that order. Was passed that order, he's also under COVID duty. You see, you have to stretch it to a logical limits also.
50.
Because this is apart from the basic benefits you will be getting as a government servant. Suppose you are elaborately felt from my lord that you are entitled for these things. Suppose you are denied for anything out of that.
No, this is beyond those benefits I'm entitled to, as per the scheme. And the order passed by the Honorable Single Judge is that I was not a health worker. But that was not their ground. Their ground was that I was not on duty. COVID-19 duty. But the document says
health worker who supervises water supply connection to hospitals.
Yes,
ma'am. It can be a health worker. That's
why the scheme has defined who will be covered under the scheme, as your lordship has gone through that definition clause.
So by which order you were drafted by the government for from COVID duty? Which order you have relied on before the civil judge?
That order is not there, but again, impliedly, page 50, these orders say that
implied in a
they
admission has limitations, you know.
I don't have that document, but this document says that I was on COVID-19 duty. Beyond this, I cannot satisfy your lordship.
No, you should be drawn to see the wording of that policy.
Yes.
You should be drawn to COVID related work.
Yes, ma'am.
Where is that drawn to evidence? If you go to the COVID work on your own,
yes,
that's very laudable, but you will not fit into the scheme.
No, as per government's order, I've gone.
No, by which order you were drawn to the duty? You are a government servant, you are bound to do your duty, everybody has to do it, is one thing. You should be specially drawn to the COVID-related duty. Where is that order?
Well, plus one order, page 50.
50.
50. This is the letter of the executive engineer.
Your designation is?
Assistant engineer, public health. Annexure 8.
These are all.
No, this you have shown, and this much after maybe your.
These are all post-mortem. That is after the death document.
Yes, ma'am. This is of
The anti-mortem documents we need.
How can a document suggest that when you are dead, you are assigned to COVID duty? So anti-mortem, you have shown this actually.
Not only that.
Yes.
The authority says he is not the jurisdictional. No, he is saying I am not the jurisdictional authority.
Yes, ma'am. But they admit that I was on COVID-19 duty.
No, they have not admitted.
How he will? He is not concerned with you at all. Ganjam R&B division number 1. Inside they say, Sri
Vinod,
working under control of the executive engineer, GPH.
GPH.
But he is not GPH.
The immediate authorities, assistant engineer.
Executive engineer, GPH, subdivision, Barampur. He is not GPH at all. One who has issued is R&B.
Yes, ma'am. Then comes, that is one document.
So you are leaving that at that level now?
Yes, ma'am. This is the document which certifies that he was working.
Kindly see.
If I fail, my lord, this document fails you, I'll come to
That's not a question of you failing.
This
You are trying
discussion.
to establish your client's case that there is some document which drafted you for government by government for COVID duty. So it's not a question of you.
Yes, ma'am.
Whatever is there. The case is as good as it is presented to the court. So
I'm placing.
you show something where you have shown you have shown the single judge, learned single judge, or the authority that you are drafted for COVID duty as specified in that.
Page 53, my lord. The assistant engineer, Barampur, GPH subdivision, Barampur.
1 second. Now your submission on page 50 is over?
Yes, ma'am.
Over. So you agree that that has been issued by some non-jurisdictional authority?
Yes, ma'am.
Okay. Next.
With reference, my lord, this is by GPH assistant executive engineer, Barampur. He writes to the executive engineer. Subject is performing COVID-19 duty by late Shripad, assistant engineer.
Again, the problem, Mr. Patra, during his life, he was drafted. It could not have been late, Mr. Patra, who did so that's the problem. So you have to simply show one document where you are drafted for COVID duty during your lifetime.
That document I have not filed, my lord. But I can.
Do you have that?
Beg your pardon, no, I don't have the document, my lord. But these documents say that I was on COVID-19 duty. And I cannot.
COVID-19 duty as defined is not the duty you are arguing.
Yes, I understand.
Doing duty during COVID-19, perfect. You work during COVID-19, there is no dispute. But applicability of that Pradhan Mantri Garib Kalyan insurance scheme, they have mentioned certain criteria.
No, who will decide to draw you to the COVID-related duty? One officer favoring the another officer.
Yes, ma'am. That is dispute between the two.
That they will be all questioning who should draw these officers to the COVID-related duty. Who is the authority? Is it under some act? No, central act is there.
I think collector.
Collector. Collector. In case any dispute arise, collector will decide.
No,
collector.
Who will give the duty?
Who will
draft the officer?
Collector. Where is that? On what basis collector? Because it helps your defense. That's it. There should be some authority who will draw these officers from that particular department to COVID-related work. There should be some drafting officer. Yes. Otherwise, anybody will say to favor, and when person is dead, many will be sympathizing with him. But we have to see policy of the state.
That document I don't know.
Definitely. Who should decide? Which is that act? Central act.
That scheme, man.
The scheme is drawn under the central act only. mass disaster, epidemic, endemic prevention act, something like that, na? Very old British legislation. Very old act it is. Now, that came because we did something. That COVID notification was issued under that act. Which is that act? Just see in the Google. Then look into it and come back. So you are not assisting us properly. Who is the drafting officer? What is the parameter? What are the parameters of the scheme? Collector. Where is that?
That because
You see that page 91. Page 91.
9-1.
Most likely,
The collector, after each countersigned, shall transit the form to the competent authority as notified by the government, health, family, and all.
91 regarding claim or regarding drafting
That
of
is
the person?
claim.
Story is very
Claim.
specific.
Claim.
That
Who has power to draft?
claim? May not claim. Look at the page 63C of that.
Yes.
The scheme is issued under which statute?
that is not been
Disaster
mentioned.
management.
No, that may not be mentioned, but some
Not
research
mentioned.
has to be done by lawyers.
I'll examine.
Which it is relatable,
I'll
how
examine.
such schemes are interpreted. They're all social welfare schemes. At the same time, government's money cannot be eaten away by some officers. Who drafts the officers to the COVID duty? Is it a district medical health officer or a district level officer, some deputy commissioner, a district collector? There should be somebody, na?
Yes.
Yes, look into it, come back. 20-30 minutes or over again. Just go. We'll call this matter week after next to enable advocates to prepare more and come for our.
I'll answer that part.
Yes. Your clients have come now. Who is that?
On behalf of Madam Jena, I may be permitted to submit that the appellant wife is suffering from
Yes, I'm. Yes, sir.
There is a delay of 27 days.
27 days. Who is your opponent?
The state commission, the election commission is appearing also.
Election Commission.
Yes.
What is the matter, sir?
And interestingly, in this matter, the same order, there are two election disputes. So 4 writ appeals are filed. 3 have not listed the identical matter. So if your lordship condones the delay, list all the matters for disposal.
You appear for the Election Commission?
No.
No.
Mr. Vijay Kumar Das.
Mr. Das is here.
Notice already served.
No,
It
they
has
have
not
not
been
got-
Petition. Mr. Das was appearing.
Yes.
Copy of the writ appeal has not been served at the state council.
Writ appeal. The state also.
They nothing.
I'll give you an extra copy.
That's all.
What is this matter shortly, sir?
The dispute is that Panchayat Samiti member and the chairperson, the same person has expired. So the question arose whether the post of chairman is to be fulfilled of first or the post of Panchayat Samiti. In fact,
No, I did not. Sorry. Kindly repeat.
Panchayat Samiti member has been elected as the chairperson
of the panchayat.
The same person expired. So vacancy arose. Chairman.
Chairperson expired.
Casual vacancy arose because of the expiry of the chairperson.
So casual vacancy in the chairperson, that has to be elected first in between the existing members, the 17 or 18 members. So then the question of, because if
then the question, you did not complete the sentence.
Indirect election, that's why.
Indirect election will take time.
Direct election will take time because Panchayat some members election is take time because it's direct election. But the chairperson is the indirect
the
election.
elected members will elect.
Members, right?
That's why in view of this Honorable Court's decision, 3 to 4 decisions are there. When the casual vacancy arose, my lord, what happened? Honorable Court said that yes, direction was given. State Election Commission issued the notification with regard to the casual vacancies. So first casual vacancies to be filled up. Because of the administrative post is the chairperson, then it's a indirect election, and direct election is subsequent. That is why State Election Commission notified to fill up the casual vacancies.
So that's when you say subsequent, it is statutory mandate or it is?
That in fact, as per the Panchayat Samiti Act and rules, which election is to be taken for?
It's silent.
That is not there.
But there was one judgment of the apex court from Andhra Pradesh.
Yes.
Sanjeevayya versus so and so.
Yes.
Where the apex court said, I don't exactly remember.
KRISHNA also one judgment that the Constitution.
That was under the RP Act. The which I'm mentioning. The Sanjeevayya versus
all those decisions have been taken note by the Honorable Single Judge, but unfortunately
he says that the election should take place to that vacancy. Shortly thereafter, chairman should be elected. That is the law.
No, the judgment is, my lord, the casual vacancy in respect of the chairperson, the casual vacancy is to be elected first because it is an indirect election. That should take less time.
Correct.
So in respect of direct election,
it will take its own time.
Right.
So with the administrative post, that's why also 4 to 5 decisions in this Honorable Court decision also a given decision. But it's very unfortunate and all single that in fact we cited all the decisions.
But held that contrary.
All cited decisions are cited. But in fact, they have not referred anything. Why they
take out that Sanjeevayya versus so and so, that 1950s, 60s judgments. Sanjeevayya. I also don't know. It is Sanjeevayya versus so and so. Chapalgaran in election law. He has given that judgment. Take out this judgment. Asnoti Kar versus Election Commission of India. Karnataka High Court, Justice Ravindran judgment. Asnoti Kar. ASNO. TI. Asnoti Kar. Some Asnoti Kar. I don't remember the name. So memory is playing trick. Asnoti Kar versus Election Commission of India. ILR, Indian Law Reports, Justice Ravindran's judgment. Yes, identical, almost similar question has been.
Similar question. Also, another point is when the State Election Commission issued notification, subsequently collector in fact accepted that notification and also they notified when the election procedure will be conducted. By that time, this Honorable Court interfered and granted stay. So my humble submission was
that would not have been.
That section 243 of the Constitution
bars interdiction of any proceeding other than EP.
Should not have been in stay.
That is also in the Christian's judgment. That is a 96 Supreme Court clearly said.
Why 96? That famous judgment.
Punnuswamy's case.
Punnuswamy versus returning officer Namakkal.
Yes,
50s judgment. 1951 perhaps 52
When the election process is in motion.
Correct. It should not be halted.
So the interfered and said that if despite that 4 to 5 judgments are there, also I'm not saying just they referred all these judgments, but didn't say that why they deferred all these judgments.
But nobody challenged the interim order. Writ petition has final disposal.
Dispose of.
No,
Anyway,
we wanted the
could you get
intermediate
that,
counsel, they will dispose of the matter.
Could you get that, this one? We need a little speedier researcher in our court.
Next week.
Take on anybody here. Can anybody help us?
Yes, my lord.
Asnotikar versus Chief Election
That
Commission.
is AIA 1967 Supreme Court.
That's Sanjeev Ayya.
1211.
Yes, Sanjeev Ayya.
AIA 1967.
67 Supreme Court 21211. So equivalent is 67 SCR volume 2.
That's what.
480.
That is referred in Asnotikar.
Right.
Asnotikar versus Election Commission, where writ petition was filed for filling the casual vacancy first. In that connection,
D. Sanjeev.
Yes.
So in also this honorable court, in our High Court, in pre-judgment, unfortunate division bench,
have they referred to Sanjeev Ayya?
No.
So have they referred to Panuswamy? Panuswamy they have referred.
Yes.
So
But Panuswamy related to parliamentary election.
The question is all the decisions have been taken note of, not dealt with the way actually.
they have not dealt with this, never said that yes, we deferred with this judgment. So never said nothing. There is a constitutional mandate, my lord, once 243O is there, so it is a bar.
Who appears for the other side?
Notice has not been issued.
Notice has not been done.
Limitation for limitation matter. That's why can we cut down the limitation and it gives a date for hearing.
It takes us up to particular distance. Then from there we have to develop that. And set apart, there is another constraint now. Election law is statute law.
Yes.
Whatever is stated in the act, correct, that alone to be looked into. We cannot evolve our principles on that.
Yes, ma'am.
The Jyoti Basu versus Devi Prasad Ghoshal,
Right.
82 Supreme Court.
Very famous decision.
Therefore, that constraint is also there. We cannot go on interpreting to evolve some principles that are alien to the statute. This is how Apex Court has said, Justice O. Chinnappa Reddy said.
In that AK Hassan Uzzaman, that no interim order can be passed.
That's what.
But despite that notification, all these things, interim order granted and also final.
Yeah, you have said it twice now. Yes, we'll issue notice now. We'll issue notice because there is a short delay. After having their say, we will condone that. We will consider condoning the issue emergent notice. Which is to be furnished within 3 working days. In addition to taking usual steps, the appellants are permitted to serve a copy of the petition on the learned advocates who represented the opposite parties before the learned single judge.
Also state government.
Immediately after service.
Also state government. State government.
Your for state government.
The state council actually from 1, 3, 4, 5, all state council.
You are all in the same petition, similar petitions.
Yes.
The petition has not been.
Other petitions have not been listed. Therefore, I say I have to serve copy in the state, and the election commission is here. I can serve a copy.
Yes,
only one notice will go against
the election commission. I can also accept notice now.
But you are a senior advocate.
They are also challenged. Election come.
No, that's all right. But there should be an advocate on record. There should be an advocate on record.
No, he is the advocate.
So he is not designated. Shri so appears for election. The senior panel counsel appears for the election commission in India. All right. Post these matters along with other writ petitions, you say.
That is my lord.
Yes.
WPC.
That Asnotikar must be ILR 1999 Karnataka, 98 or 99 Karnataka. Just look into that judgment also. Yes. Call along with so and so. When
give the
piece of paper.
I'll give the list.
And give us the citation to us also. We will also look into and come.
Yes.
They will take your case up to a particular point. Thereafter, you have to develop on your own.
Yeah.
The stay of who judgment
The limitation is there, but
the limitation of condone.
No,
Notification.
Limitation.
Notice.
Yes, both
limitation and appeal.
Appeal both.
and also
There is
the
no
stay
question of
matter
saying.
also. Stay is there. So notice.
Also, contempt will file because
If contempt is filed, you just mentioned before us.
Yes.
It is open to the parties to seek early posting of the matter if there is any threats like contempt or the other proceedings. Okay, number one.
Within the
Three working days. Three working.
Three writ appeals are there.
Yes.
Nice.
Please give. Please give. Push these matters along with other cognate matters. Yes.
Item 22. Rights of portion by Lord's order that the comparative.
I have received the affidavit just now. Yes, I have received it.
We call it after 4 weeks, 3 weeks.
No, my lord, they have to tomorrow that they only comparative statement. My lord,
they have to obtain instruction.
yes, yes.
Or you will object that.
No, my lord, I can.
So we find that whenever we say the direct them to obtain instruction,
Yes, yes.
so that doesn't help.
Yes, that's it.
2014 matter. Very old matter. Yes.
Old matter, sir. That's why I am.
When will you get?
Next week.
Next week.
Huh?
Next week, anything.
Oh, next week. It's all next week. Some day. Yes.
You are filing this in the court.
Yes.
Yes, ma'am.
Just now he has filed and
Affidavit dated of date is filed in court by on behalf of the petitioner by the learned counsel. The same shall be taken on record. Copy served on the learned DG to enable him to obtain instruction.
No.
List on 22nd August, July 2025.
let's make it 27th.
27 is holiday, no? July 27. July 27.
We are on
26. 26.
26.
Yes.
26. No holiday.
28 we can make it.
August, sorry. 28.
28.
28.
Okay.
Item 34.
Yes, sir.
State of event. State of event for the affix.
Lordship, here last occasion, Lordship directed to call for the LCR Millers. LCR has come. I'll need Millers. Copy of the LCR. Yes.
Just you
Noting is noting there.
you look into the LCR and both of you look into the
Yes.
LCR and make submission.
Copy of the LCR may be supplied to us.
Scanned copy will do. Government had physical copy.
Hard copies.
Hard copy. Shall take print out.
Yes.
The registry, in compliance of the earlier order passed by this court, the trial court records have been provided, which are available. The soft copies are available. The learned AGA for the state and learned counsel appearing for the accused.
But you continuation of what flow.
Accused shall obtain copies of the same. Registry shall facilitate the supply of the medical reports.
Item 35.
Petition of the post of serious clerk in court merit was upgraded
Post was upgraded as
Upgraded to as bench clerk, my lord.
bench clerk.
Yes, ma'am.
Mr. Malik, so many counsel they are appealing for the private parties.
Yes.
Yes, ma'am.
They have excused themselves for not being right.
They will
The
be needed.
upgradation, my lord. But
No,
they,
can you argue without your friends here?
I mean, if
We
they
have some date.
if they are
Yes, yes.
affected,
Because they are affected.
they are
They are
affected.
affected.
Then
now nobody is affected because everybody is retired. All retired persons.
In fact,
I am retired.
three
They are also
disciplinary
retired, my lord.
disciplinary proceeding has been initiated against him. Out of three, one punishment has been imposed. So therefore, he is not eligible for the promotion. So that is
I am
the sole
claiming promotion, my lord.
promotion and
Promotion of post.
Whatever had happened, that should be given.
Yes, my lord.
yes.
I mean MSCP, RSCP.
No. Upgradation of post as per the commission.
Upgradation happened when you were in service.
Yes, ma'am.
When it happened?
That upgradation when I was in 2006.
2006.
Yes.
You retired in which year?
I retired recently, my lord, 2022.
But all these years, what were you doing?
I was in proceeding, my lord.
Huh?
They rejected letter, my lord, because two proceedings were pending, my lord. They say because the proceedings are pending, we are not upgraded. But proceedings are
Three proceeding.
Happens automatically it happens. Whoever is holding that post, if automatically upgradation goes with the candidate.
Grade 2 to grade 3.
Correct.
That's
With upgradation.
my defense is that due to the pendency of the disciplinary proceeding and awarded punishment in one DP and the other is exonerated.
But is that a relevant consideration?
How that can be?
So you are adopting irrelevant consideration which are not germane to the issue.
How can
But if there is any guideline, you are supported by guideline that whenever you are granting upgradation, you have to consider his credentials. Then only that will come to your rescue.
Right.
Otherwise, you cannot on your own treat it as a
promotion. All this problem arose because your approach to matter was defective. So simple a matter, 1 minute matter, where upgradation happens, it happens to everybody who is holding the post.
If we can some other day and
he will not get promotion in the upgraded post. Suppose if your argument is accepted, further group 2 to group 3 or group
2 to group 3.
Upgrade after upgradation.
Yes.
So beyond that upgraded post, you may
promotion you can find. Just look into.
Yes.
Justice Ramajoyce has given a good explanation. What is meant by upgradation? How it is effective? These things are discussed by Justice Ramajoyce in his services under the state. Yes.
Short that.
31st.
Item 37.
Yes, my lord, I have filed a
7 and today this matter will be taken next week.
government's appeal, my lord. The ground on which appeal is filed, that ground is no more substituting. Appeal has become because of the recent circular of the government, my lord. Government has amended circular. Therefore, appeal is not
You
substituting.
say that compassionate appointment.
No, my lord. Not compassionate
Please
appointment.
provide that circular because compassionate appointment we have already lots of past orders. Their past orders.
Third RAC.
Regarding RSAP, my lord, recently government has
He is citing something, a new decision by the government.
not decision, my lord. The resolution of the government. Recent,
Provide it to him.
I have given a payment. I have given.
So let him obtain instruction.
Yes.
Registry, one page. Give him. Go take beyond copy.
You make photocopy or you can get it out.
One more.
I can give another copy. I can give another copy.
Well, On 31st we'll have that. 28th? or 25th we will have 25th.
Item 38.
May I, Your Lordship? My Lord, in this case, I am the
Number one. Copy of the writ appeal has not been solved out. Copy of the writ appeal.
Share a copy, brother.
Helps. In course of, by tomorrow, I'll see.
Call next somebody. Give it.
This is after notice, when do you want?
I'll serve by tomorrow. Your Lordship fix any time.
26th August.
Hello.
Item 40.
Your Lordship.
Yes.
Copy of the rate of appeal has not been solved to me.
Notice is ordered now. Notice is ordered.
It's regarding rehabilitation RA rules. RA rules 2025. Your Lordship.
Wolfgang Friedman. That book.
My Lord, we have already.
You have submitted.
Yes, well.
You
No copy has been solved. No copy has been solved.
2025 notification on sir.
Dispose of the
My Lord has passed.
Covered by judgment.
Yes.
Covered by
That is
judgment.
WBC number 16808 of 22.
Do you have a copy of the order?
I have given that number.
You give the writ number and writ appeal, they will find it.
It's a writ petition because it's arising out of
That was writ petition.
judicial.
That amendment.
Yes, my amendment.
This is a
425 amendment.
Yes.
4th April.
judicial establishment.
No, Millers.
No state.
No, Millers.
Police establishment.
Police establishment writ appeal order is also there.
Yes, I have that.
The subject matter of this appeal is substantially similar to the one treated in WP number
16808 of 2022. It's the same.
wherein a molded relief has been accorded to the citizens, employees. First off, the counsel for the respondent employee submits, and we agree that the like cases should be decided alike, and therefore the benefits granted in the cognate petition need to be extended to the respondent hearing as well by requesting the appeal. Ordered accordingly, and writ appeal is dismissed. All conditions in the cognate order would apply mutatis mutatis. Okay.
Item 2.
Dispose of.
Lordship dispose.
Yes, dispose of.
They are saying that
Item 41.
Dispose of.
51.
Yes.
May I please? Should after this matter, Lordship may permit me to file a small written note as well as date chart because it will dispose of by. I am from the Union of India. I have challenged the order part by the Honorable Single Judge. Small point, my lord, that though he has been reverted, his scale has been Honorable Single Judge directed to fix in a higher scale.
because reversion has he challenged?
Yes. Reversion, he has filed reversion as well as Lordship.
Correct. So reversion was set aside.
No, reversion was not set aside.
Now Mr. Pal says this policy said.
Now, Your Lordship, kindly see the judge order passed by Honorable Single Judge.
So since you are seeking time, Mr. Both of this, please be.
It's ready in the second week of
This case, Honorable Single Judge passed order in light of the judgment of Honorable Supreme Court. That in Supreme Court of year 2025, in the past.
Were not there. We are on a much simpler issue. That if your reversal has been set aside, Mr. Gupta is saying that reversal has not been set aside. So you please examine that way and make your submissions. Take time. Don't straight away go to the citation, so and so, so and so.
No, I have already filed citation manual.
Not necessary. Actually, you have to get there.
Yes.
26.
I am not claiming my lord promotion. I am claiming
26th August.
my lord 6th.
26.
26 August.
I am not claiming promotion. I am claiming
Let us see.
pay protection, my lord.
Yeah, yeah.
Item 42. This is a matter.
I will be appellant in the first two appeals, my lord.
Well, in this case, I'm filing objection to the one appeal which has been filed by the state. I am filing IA for objection to the IA for condonation of delay filed by the government, state government. And another, my lord, in the appeal, the last appeal which has been filed by my lord friend, my lord, I am filing counter today. I have sought copy just now. I am filing counter to that, my lord. It is a connected matter and having
Four
matters having the multiple issues to be adjudicated. But and in this case, in my first two matters,
So Mahapatra, if you object to state's appeal, but you are also the appellant.
In my appeal, my lord, there is no delay in first two appeals.
So technically, their appeal also, you are the
Same order is
Same order.
Same order.
On my lord, my duty to, my lord, object the appeal. For that, my lord, filing appeal. And in first two appeals,
Since your lordship, common order has been challenged.
in first two appeals, Lord Senior, my lord, J.K. Rathu will appear and conduct the case. He was
you have to permit the learned senior advocate to
Yes.
say a few words.
This is a very grave matter. What really has happened, this is a governing body of a college which has now continued for 24 years. The normal statutory period is supposed to be 6 years, two periods, 6 years. And there is a single bench judgment staring at them, which has said that this practice which has continued should not have happened, immediately constitute a new governing body.
So maximum period a governing body can be in power is
For 2 terms.
12 years.
No, for 2 terms.
3 years. 3 years.
6 years.
6 years.
3
Consecutively.
Consecutively 3 years.
It cannot be consecutively 3 years. It has to be 6 years. If it is
total is 6 years. And so therefore that was a single bench judgment, which apparently they had challenged, but there was a concession because there was a contempt, there was a concession that we will not press that writ appeal.
Yes.
Subsequently, what happened is when the ADM took over, because this governing body, which is now for 24 years, obviously will have its own person, government appointed an ADM.
Under which law? Which law?
The relevant rule which is there, it gives you a power to the state authority.
To do
yes.
That. Which is that rule?
1991.
What are the names of the rules? Under which act the rules are made?
The Education Act.
Yes, Your Worship. The Orissa Education, I'll place the whole. Orissa Education Establishment, Recognition and Management of Private College Rules, 1991.
In this book?
Yes, Your Worship. 681.
Page number?
680. This color.
681. Yes. 681. Yeah, where is that the particular provision?
681. These rules are made under the Act only. Yes.
Lordships. The court is the power to
These rules say what?
So the Orissa Education Act 1969 may also be seen.
Which section?
Lordships.
Process.
This is not there. Huh? No.
What is the issue?
Your Lordship, the issue is this, that after that ADM was appointed, they went to before another bench, saying that the ADM could not be in control. We should send the names of the new governing body. To that extent, the single judge allowed the order. That was appealed by the state. The state said, no, we have powers. And according to the earlier judgment, we have taken over and we are going to see that the elections are held and proper names go. So that is the state appeal.
Yeah.
However, Your Lordship, after they got that order, what they did is the existing principal in charge was removed
By the
old governing body, which is continued for 24 years. Then we came.
That was removed during 6 years or after 6 years?
No, after 6 years. That was recently. Recently. So that very single judge said that I had only given you powers that, okay, ADM will not be in control, you send the names. But you could not have touched the people who are in position, because the principal in charge would have been the ex officio member of the new governing body. To that extent, an order was there in my favor. However, what the court did, he said, okay, I will make a third arrangement. Neither your principal will stay, neither this principal stay. Some other college principal was appointed as a temporary principal. To that extent, we came in a writ appeal. They came in a writ appeal saying that no, we have the power to remove the principal. So that is how all these matters today are.
Provision is Lordship.
That is how
you will not pass any adverse order without hearing you.
That is how the whole thing now stands. However,
so this is a matter relating to tenure of elected body.
Yes.
Governing bodies. Then power of the government to intervene after the expiry of 6 years, there being no election.
No, it's the power of the state. Of course, that power is there. The state, after just one of the benches, Justice S.K. Panigrai's judgment was that there should be fresh governing body. Now, steps for fresh governing body should happen.
Three years.
He says more than 2 terms.
2 terms. Consecutive presidents. He cannot be president for third time at all.
Act says 23.
Act says 3 years.
That is 133. His lordship is 23 proviso is third proviso.
That 7.6 has that. My old book did not.
7.6.
6. It says any other person. Page 134.
4. The managing committee or the governing body, as the case may be, shall continue in office for a term of 3 years from the date of its approval by the prescribed authority under subsection 2, and shall be reconstituted in accordance with the rules. This prescribes 3 years. Thereafter, fresh election should take place that way.
Since if 3,
that will conflict with each other.
no, they're not in conflict.
They are not in
3 plus 3. That should make 3 plus 3.
6 years.
But the term is contained below 3, it can be less than 6 also, for some reason. Because it doesn't define the term particularly. So
Maximum is 6.
maximum is.
Kindly read section 7, subclause 4, subsection 4.
A managing committee or governing
With
body
the third proviso to Rule 23. Reconcile these two. Managing committee or the governing body will continue for a term of 3 years.
3 years.
3 years. That is subsection 4.
4.
Third proviso to Rule 23. Provided for that governing body.
Third,
Third one. Provide also that no person shall be the secretary. That is not applicable to you. No person shall be a member.
The rules?
Yeah.
Rule 23?
23.
Third
proviso.
This
Provided also that it reads page 690.
No person shall be the secretary of more than 2 terms.
That will not apply now. Come to you. That also come to your case. That's your case.
No. In fact, if suppose somebody has continued for 24 years, so obviously the secretary now has continued for more than. I mean, all these violations have happened.
No, for body there is a separate rule. For secretary there is separate problem.
That has been subsequently amended in 2020 lots. This incorporation has been made in 2020. Earlier, that was not there. The senior most teacher was the member secretary, and consecutive term was also applicable to. But here, the principal will be in 2020 amendment made. Only principal will be the member secretary. And these 2 terms has been added instead of consecutive term. 2 term has been added.
Which means it's a restriction now.
So the proviso which says 2 terms.
Yes, ma'am.
That is there even now for principal.
And in view of the honorable single judge directed for a election and submission of the proposal that has been submitted before the government, that is pending for approval matter. That has already been done.
Yes, there are few things which have happened, which I think the subject matter of the happened, which I think we should bring it to your lordship's notice. This matter was heard in length before Justice Saran and along with and the Justice Rath. They found that illegality. In the midst of it, the court asked the government, it considered that section 7(6) and looked at the affairs of the matter.
Your appeal is also you are challenging the same order.
We are challenging Justice B.P. Satpathi's order, not Justice S.T. Panigrai's order.
You are agreeable with Justice Panigrai's order?
Yes. We want a new governing body.
Challenging that order.
They are saying what after Justice Panigrai's order, the state exercised its power under section 7(6), appointed the ADM.
7(6).
7(6). Of the Education Act 1969 and appointed the ADM. Page 134 here.
Because they should not be acting many persons. No person or appoint any person.
Any person. So ADM was appointed.
No, that order has been quashed by the honorable single judge.
That is why the state is under appeal. They said that if somebody is continuing 24 years, now he obviously want his own persons to be there for all fairness and for the institution.
They are changed.
But now the writ appellate court, this court, has to hear challenge to both the decisions. Because you are challenging.
There are 2 sets of one set of judgments is by one judge.
Yes.
Another set of judgments is by another.
Yes.
All the 4 judgments are in appeal.
Yes.
Okay.
But they had given a concession before Justice B.P. Satpathy that they will not press their writ appeal. There is only one writ appeal against Justice Panigrai's judgment, which is filed by this 24 years old governing body. They will not press it. That concession is there. That is why Justice B.P. Satpathy passed this new order. Fine, you send the names. Beyond that, don't do anything.
And that order has been challenged by the government.
And not such as what happened in the midst of that argument. The court said that I find that this is completely messed up. Again, you select somebody as a person to take in charge of this college. This college is today we're not able to run it at all.
No, they have handicapped melon.
We will hear you.
This is what the government did also. But unfortunately,
kindly be seated. We'll hear you. We will not pass any adverse order without having your arguments. Yes.
But unfortunately, this order the government had prepared and it was submitted, but no orders could be passed. And before that, a retirement happened.
That principal retired.
The Chief Justice was hearing.
Problem is that once you say that before one division, one single bench, one court, you are saying a stand that will not place.
They.
Government. Correct. But it is not before the same judge. Suppose I am sitting in single.
Yes.
There are 2 writ petitions before me.
Yes.
Fine. One, my esteemed senior, one writ petition and one petition before me. How can somebody saying that we'll withdraw the petition before Justice?
On that basis, on that concession, they took the second order from Justice B.P. Satpathy.
Otherwise, he would not have granted that order at all.
That is what he said. At the outset, learned senior counsel contended, even though they have filed an appeal against the order dated 18/10/2022, so passed in the WPC 10310/2014. Writ appeal number 1528 of 2022 has been filed, but the petitioner will not press the writ appeal if this court will interfere with the order passed by the government on 12/5/2023, which is impugned in the present writ petition. That was the order appointing the ADM.
Having taken that order, they are in challenge again.
Yes, they said, so this was their concession. And this is the order.
State has challenged that.
State has challenged because state felt aggrieved that I have you exercise that under 7(6).
That concession
will bind or not is the question.
And it's recorded.
But once concession is given and an order is taken from the court, can they turn around and say,
both the writ petitions should have been taken up together. It should be placed before the Chief Justice to be decided one bench.
That way, that one bench. Then this will happen when 2 benches. 2 benches identical. But there are judgments which say, once a litigant gives up his litigation and on that basis derives some benefit at the hands of a judge, he cannot subsequently turn around and say, no, I should be permitted to challenge that order. What is the challenge? On what ground you have structured your challenge?
No, my lord,
you are in challenging that order.
Yes, my lord. No, we had challenged the earlier order.
One second. Did you make that concession before the learned single judge?
No, that concession was not given. That was, my lord, lordship.
Judge himself
lordships are directed that you proceed for, because we are praying for reconstitution of the governing body by elected body. A fresh governing body by elected body, fresh persons.
No, we are asking you.
Yes, no, my lord, I am coming. Prior to that.
Again, we are asking.
From 2022.
We want to ask you.
Yes.
If you want to hear us, kindly hear.
Lords.
Otherwise, you make your argument, we will make our order.
Lords.
That will not do justice to anyone.
Lords, I am, sir.
We are asking you, did you make that concession before the judge?
No, my lord, that was
not. You have not made concession. Have you taken up that ground saying that we have not made that concession, but judge has written it wrongly? Have you taken up that contention in your writ appeal? You have taken?
I'll go through.
Just look into it. That is very simple. It's not the case one on the Bharti case. This is the only point involved. How can you maintain the appeal? If you had undertaken, and on that basis you have taken an order at the hands, you have snatched an order at the hands of a judge of this court, then you cannot challenge on this one, unless you have stated, I never gave that undertaking to the learned judge. By mistake, learned judge has said like this. If that is so, then we will send you to the same judge.
Yes,
because Apex Court said in 86 Supreme Court.
It was being argued by Senior Counsel Mr. J.K. Ratho, who is appearing here in this case also. He was here and he left the court for his personal difficulties. Lordship keep it to.
Where have you taken up that contention to maintain the appeal?
I am going to. If your Lordship is direct.
Together we will go through. Yes, just turn the pages.
Mr. Rauka was waiting for maybe
Yes.
for this case, but
How can you maintain the appeal? Where is the sanctity to the words given to the court? Court is a temple of justice.
Yes, yes, ma'am.
On that ground, and therefore, madam is saying you cannot do all that one.
My lord, that is in WA number 2387 of 2024, which has been challenged.
Now, how many grounds you have taken in that?
Well,
how many grounds you have taken up in the appeal?
In that appeal,
total grounds, how many?
Total, my lord, 6 grounds.
6 grounds.
6, 7 grounds.
Just glance them. Whether you have taken this grounds.
That
learned single judge have grossly erred in saying that we have given concession when we had not. You do not appear to have taken.
Against that order, Mr. Mahapatra, you have also filed appeal. Justice Sarpathi's order.
No.
No, they have not.
That
other order they have.
You have challenged.
Subsequent, another order was passed. My lord, where the
You kindly go through that from the court.
It is the subsequent appeal, my lord. We have not challenged. Where, my lord, concession was given, that order we have not challenged.
That order is not challenged.
Subsequent order, my lord friend has come. The last appeal, he had filed the writ application challenging her demission to the post of assistant professor from the post of in-charge principal. When in-charge principal from the post of in-charge principal where she was demitted, he had challenged that. And
when you were say arguing counsel will come?
Tomorrow.
Tomorrow we should have. We will fix some date for this matter. All 4B, you have to answer this question also.
Yes.
Like genealogists, they have to prepare a chart.
That's what. They should prepare a chart.
We have
Which order, what order said, which is passed, what is challenged.
And now state has challenged both orders or only one order?
One order.
That's the last order of the Justice Satpathy Miller.
No, not last.
On the ground that Honorable Single Judge has Justice Panigrahi has Miller directed to constitute a fresh governing body. But while state is in action, that impugned order is Miller's.
Where are you interfering? He is making submissions.
By the order dated Miller's 1810-2022 passed in WPC number 10310 14 Miller's directed to constitute a fresh governing body. And in pursuant to that order, government has taken steps for the constitution of the governing body.
Governing body, government has constituted. It has power to constitute the body also.
No. Yes.
No such power.
And dissolve the earlier body. Pursuant to the direction of that 1810-2020, dissolve the earlier body, Millers.
Yes. The government will ask the rest of the governing body to submit the proposal.
Constitution. He's saying government has taken steps.
Yes, government asked the state government.
And in the meantime, ADM has been appointed in charge of that.
There is such a power, no?
Yes.
Rule section 7, clause 6 proviso. There is such power. Yes. government may reconstitute the governing body or the managing committee, as the case may be, notwithstanding that the term of such governing body or managing committee have not expired. On such a reconstitution, the existing managing committee or governing body, as the case may be, shall stand dissolved. Government has that power. Yes. Government has that power to reconstitute.
And furthermore,
But
it
what is the
concerned to
ground
the
for-
direction.
Huh?
Concerned to the direction of the Honorable Single
Court
Justice
itself.
Panigre.
And your committee has been in existence how long? Last 24 hours, 24 years.
No, 24, that is misleading, madam.
How many
Because
years?
There was a society.
All right, how many years according to?
Body, the members are coming and going.
No, that
The
cannot happen.
approval, that is the approval is the matter. What is constitution before your lordship is when proposal is sent.
Anyway,
election-
you bring your arguing counsel. Not that, that cannot be done that
Let's
way.
look at order number 5.
Anyway, we'll take
In
up the
W-
meeting one day. We'll fix a date.
No, Your Lordship, I'm not standing in the way. Just order number 5 of WA 152 of 2022. Small order. Your Lordships.
Writ appeal number?
1528 of 2022.
Scroll to. Scroll.
It is their appeal. Order number 5.
The district magistrate was appointed.
Yes, Your Lordship. That is what they said. That looking at the whole affairs, please kindly put your person. That is what the.
Thereafter, Lordship, kindly have a glance to order number 9, dated 4/12/2024.
It is 2012.
May not be there. You are referring to some other writ appeal.
My lord, this is a common order, my lord, in 2387 of 2024.
2387.
Yes, ma'am.
May not be common orders.
Common order.
So you have to prepare that flow
Yes,
chart.
ma'am. They are this honorable
Like a
court.
computer program. How these things are.
Yes, my lord.
Where
We
the-
did a exhaustive date chart along with the.
Been very complex, unnecessary.
If Lordship gives me a few minutes of hearing, I'll just put
That's-
everything in straight.
That's it.
One.
So we'll call this matter on 13/8.
38 is first year of Lordships.
First week.
1st of August. 1st of August.
1st of August. All right, 1st of August. Okay? Okay. Call this matter on 1st of August. This date is chosen by all the stakeholders.
Can I make a request,
Yeah.
Your Lordships? The entire college is now stopped. No admission, nothing happening. If the government, anyways, the court had ordered that you put ADM
What is
and
the
carry
bona fide- what is
carry
the
out the
bona fide-
affairs of
Yes,
the
collected.
college.
Yes, not governing body. Lordship, kindly have a glance.
You have not completed sentence also. Still you want to interfere? No, you should not do that way. You should completely hear. And some defense may arise from their statement itself. Please do not interfere. That gives a wrong impression. And that may prejudice your right of audience.
Only saying that let the ADM be there in affairs and so that the college can run, admissions can happen, students can be taken care of. That's all my prayer. Anyway,
Today.
That's what I was.
Which is the last date for admission?
Your Lordship, this college is literally July last.
July last.
That is wrong.
Which date?
Date has not been last year, my lord. They paralyzed the entire institution.
That's all right. We are asking a question.
I'm submitting the objection we have made for the director and
We are asking the question. Which is the last date for admission?
No, that has not been prescribed. I have not taken instruction.
What is the last date for?
Yes, general date on
No, he has to take instruction.
the state of Orissa has a general date. It's a general date. No, all the private colleges, it's a general date. That +2 admission and +3 admissions.
No, general date means we do not.
Yes, +2 +3. It's a physical education. But +3 level. It won't be very different from the general.
Declared. Just ask your officer, telephone and just call over a mobile phone and ask which is the date. Your directorate will be there, na?
Present right now.
Ask
physical education.
Ask him. which is the last date. Because otherwise, the whole institution will be dysfunctional for one academic year. Yes, go and ask. Go and ask. Yes.
Item 43.
Today, I have received counter filed by OP number 6. So I seek the leave of your court to file a short rejoinder.
Rejoinder you want to file?
We also received the instruction from the Pharmacy Council.
Which date you want?
After the 2 weeks, my lord, I see that.
Urgency, anything here?
No, my lord. My lord, I am appearing for opposite but number 6.
Your time.
Yes. I have filed the counter. My lord, the sole issue is that.
No, you want to file a rejoinder, no? Call this matter on 19-8?
Yes, 19-8.
19-8. To file a rejoinder.
In the meantime.
We will file the affidavit, therefore open over 1 and 2.
Rejoinder stroke affidavit.
Yes.
My lord, I have filed the counter in the registry.
You have filed it?
Today only.
Okay. It will be posted along with that.
Let them serve a copy of this.
Serve copy also.
To all parties?
They should know what stand. Yeah.
Recorded. Okay.
That instruction could you obtain? From the directed.
We'll take a chance. We'll take a chance that they finish the hearing, I think.
On which date?
1st of August, we'll
First of-
finish hearings. The hearing finishes, it will be better.
That's